Well, good morning, uncivilians. How are you doing today? Welcome once again to the wonderful channel that is Uncivil Law. I hope you're having a great day. I'm having a great day. Everything is wonderful and awesome in Karen Reed trial world. Boy, oh boy, I'm looking forward to those experts being called today for the first time. Those experts. What are they from? That company, Aperture? Boy, oh boy, I can't wait to hear from those experts that we haven't heard from yet. I'm sure they'll be good. Anyways, things could be going better for parts of the prosecution's case right about now. The Aperture Science, the Aperture Science.
Aperture Science.
There we go. The Aperture Science people were not exactly the prophecy that yours truly had been foretelling. Surely Brennan, with his choice of experts from around the country, surely he would be able to find somebody, anybody who could credibly and even potentially honestly tell a jury that, this is totes 100% what makes sense. But apparently what we went with was Aperture Science.
Aperture Science.
Which turned out to not be such a great company after all, or at least the people they hired were not so great. Yours truly also sent an email to public relations at the University of Alabama asking for comment regarding their alumnus. The University of Alabama declines to comment at this time, citing privacy concerns. That's not a joke. I really did send them an email, and they really did decline to comment, citing privacy concerns. So that was exceptional. Yeah, I'm not sure privacy is necessarily their chief concern, but that's the one they decided to go with. So all the rest of it. Also, I have updated my own LinkedIn. As some of you noted, I updated my own LinkedIn because apparently that is a thing that I can do now. Taking you briefly to my posts page. The posts from if you go to my channel page and you go to posts, we have this wonderful post from yesterday updating my LinkedIn. As of yesterday, I'm currently the president of the University of Alabama at Birmingham. Currently pursuing, mind you. So I'm sure that will, who knows, 17 years from now, I might very well be the president of the University of Alabama at Birmingham. I mean, it could happen. Stranger things, man. So, my claim to being president of the University of Alabama is at least as good as Shannon's claim to having a BS from that very same school. In fact, I'd argue that my claim to being president of the University of Alabama is actually marginally better than Shannon's claim to having a BS from the very same school. Because I actually have 3 college degrees, which, makes me arguably qualified to be president of the University of Alabama. And him, not so much. So my claim currently pursuing is arguably more credible than his claim. And in any event, I'm currently pursuing president, University of Alabama. So please support me in my endeavors. Please support me in my endeavors. With your support and grace. With your support and grace, I too can be the president of the University of Alabama, or anything else I want. I have a dream. Exciting. Yeah. 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 I mean, I could be dean of a law school with a JD. I don't know if there's a lot of JD. I don't know if there's not a lot of non PhDs leading universities. There might be some out there. I don't know if there's someone with just a JD leading a university. Uh, there's definitely JDs leading law schools, but JDs leading entire universities. I don't know. There might be one. It'd be interesting. And then you can call me Mister instead of Doctor. Yeah, I'll be one of the very few presidents of a university whose proper title is Mister. But that's okay. I can hang with the cool kids with my Mister title. Lord have mercy. I should put a picture of Trooper Paul in my digital picture over my right shoulder. That is an outstanding idea. And more broadly, the memes that we've been generating, I need to put on the picture behind me. This is even better. Where's Just Rhonda? Just Rhonda. Yeah. Can you make me a picture of Trooper Paul? Can you make me one? And I will add him and all the other memes that you've created to the picture behind me. See, now that you've said it out loud, it just makes total sense. And I will just put him and all the other wonderful characters we have in the picture frame behind me. This is a brilliant idea, Rhonda. See, sometimes you just need someone to say the obvious. And then it's like, this is the best idea ever. See, I'm a smart guy, but sometimes even obvious ideas don't come to my attention. Then Rhonda says something. I'm like, this is the greatest idea ever. Why didn't I think of it? We can't all be equally brilliant in every way. It's sad, but true. Will I sign my name with Esquire? I do. I have put Esquire at the end of my name before. I've done that. But if you actually know a lawyer who insists on calling themselves doctor, that is a major red flag. Ian has told this story before. Like, at least in his part of Canada, and I don't know whether or not it's generally true in Canada, but at least in his part of Canada, if a lawyer uses ESQ at the end of their name, they're a real dick. That is less a thing in the United States. At least it's not been a thing that I'm aware of. So maybe that's a thing in parts of the United States where using ESQ at the end of your name is a real dick thing. I've never really seen that be a thing. I mean, a lot of lawyers don't use it, but a lot of lawyers do. I don't know that's really like a taboo, like apparently is in Canada. I've used ESQ and not felt bad about it. But if a lawyer in the United States calls themselves doctor, holy shit, dude. Holy shit. Yeah, just run away. Run very, very far. Oh, by the way, I literally had a dream about streaming last night. That is how much this is infecting my dreams. I literally had a dream where I couldn't hear the court feed, but you guys could. And so I was trying to like resolve the technical problem, right? You guys in chat were saying like we can hear the court, but I couldn't hear the court for some reason. I was like, why can you hear the court, but I can't hear the court? Why is that a thing? That doesn't make sense. And I was trying to source the problem in my dream. Audio issues apparently are now haunting my dreams. I blame you collectively for this. Also, in unrelated news, later today at the end of stream, we are planning on an interview with Vinnie Palantain from Court TV. That will be exciting. It is currently scheduled for at the end of the court day, but you know, whenever that is, so we'll see and go from there. Yeah. Dreams are like glimpses of the future. Yeah, maybe. Maybe. Politan? Politan? Politan. Vinnie Politan. I'll learn how to pronounce his name properly. Vinny Politan. We're having an interview with him later today. Vinny to his friends. Yeah. We're friends, right? Yeah. Bluefish member, thank you very much. Not as bad as a dream as being on the stand and not having dreams, you stated. It's been a while since I've had the sometimes recurring dream. I use the term recurring very loosely because it's happened multiple times, but very spaced out. But every once in a while, I have this recurring dream where I get news that I didn't pass high school, and somehow that like undermines like all my degrees. Right? It's like I get this news that I didn't really graduate high school, and my entire academic career therefore like falls apart. I'm pretty sure that's not really true. I'm pretty sure that in the unlikely event that somehow it was discovered that I didn't really graduate high school, like some sort of error, it's like we granted your high school diploma an error. I'm pretty sure that my college degree still stand, notwithstanding the now lack of high school diploma. But that's a sometimes recurring dream I sometimes have. Yeah. I don't think that's actually how it works. But in reality, but hey, it was a plot line in Law and Order. It was a plot line that Mike Cutter didn't graduate law school or something. Yeah. I forget exactly what the deal was. In the later seasons, like season 19 or something, Mike Cutter was a DA, and there was a plot line in one episode where he didn't really graduate law school or something, and he like knew about it though. So somehow he was admitted to the bar, but he hadn't really graduated law school or something. And so like, this was going to be like a scandal that, would somehow undermine his license, and or more the point, like undermine all the convictions he had been part of. And no, that wouldn't really happen either, right? That was not that's not a real thing. Like the criminal defense lawyer in that case was like, we have a constitutional right to be tried by a lawyer who works for the government. I'm like, actually, no, you don't. Strictly speaking, have a constitutional right to be prosecuted by a lawyer. I mean, not you don't have a constitutional right. The bar is going to be happy, the unhappy about it. The courts are going to be unhappy about it, but it wouldn't undo all the convictions he had been part of. That is not how that works. It might cause people to look into the cases in some sense, but it wouldn't like be an automatic undo. That is not a thing. That is not even close to a thing. You got my Trooper Paul in Discord? Excellent. As soon as the court starts, I'm going to start adding those graphics to the thing behind me. Very exciting. How did Karen's phone connect to the infotainment if the car was turned off? Don't ask questions like that. Don't ask questions like that. You'll hurt yourself in the confusion. Yeah. Shannon has a dream. I dream a dream of time gone by. Da 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 da. Something, something, something else. I need to work on my lyrics here. If your criminal defense lawyer turned out to not be a real lawyer, you might have some sort of claim there potentially. But even then, I'm not necessarily sure it would result in an automatic reversal. So that would actually, I don't know. I'm sure there are cases. It must have happened. I'm sure there are cases on this point where there has been a criminal defense lawyer or a criminal who's been convicted with representation by a person who turned out to not be a lawyer after all. And I'm willing to bet, without even looking it up, that the courts have said it's not an automatic grounds of reversal. That would be my bet. It's like I got $5. I got $5. There's been a case in which someone's been convicted with someone representing them. Everyone believed to be a lawyer at the time, but then turned out to actually be a fraud. And I bet you there's a court of appeals case that says, close enough. $5. I bet you that case exists. Yeah, that sounds right to my mind. Just like Suits, please don't bring Suits into this. Suits is a bad show in every way. Suits makes me sad. It is not a law show. And its name should be, take that name out of your mouth, as Will Smith might say. Anyone who mentions that show is getting a timeout. You've been warned. If you mention the LA version, you get timed out twice as long. Can I give an example of direct versus cross? Well, the only real difference between direct versus cross is in direct, you ask open-ended questions, and in cross, you can ask leading questions. A leading question is a question that suggests the answer, strictly speaking, on a technical level. So a yes-no question isn't strictly speaking leading. A leading question is a question that suggests an answer. So a direct question would be like, where did you go? A direct question or a cross question would be like, you went to the park, didn't you? Right? Because that suggests the answer. Like, did you go to the park, though, strictly speaking, is not leading. Because did you go to the park does not suggest the answer. In case you technically care. Now, how different judges will interpret that, some judges, will draw differently, or they will care about it differently. But that's the technical delineation. And so that is the difference, whether you can ask a leading question, a question that suggests the answer or not. That's it. Can you ask a question like what? If what is understood by what is sufficiently clear from overall context, technically. Yeah, technically, if what is sufficiently understood from the context, then yes, what would be an appropriate question? Oh, yes. You know what I need to do? I need to open up the court feed so when the court starts, I can bring you the court feed. That would be a good thing for me to do, like a competent streamer. Oh my God. Guys, there is a scandal happening as we speak. Holy shit. I have breaking news. I don't think you guys are ready for this. It's way too early for this. Spinny fan is not spinning. A tragedy has occurred. Spinny fan has lost the will to live. Come back, Spinny fan. Please come back. No. Spinny fan was ever reliable. Spinny fan was our constant companion. You bastards killed Spinny fan. We did have people design some alternative logos for the channel as well. Let's see if you guys like some of these alternative logos. Hold on, I have to find them. Where are the alternative logos? Which of the many discords are they in? Where's my logos? All right, there we go. All right, found it. All right, hold on. Yeah, hold on. All right, let's see. Now, how do I change my logo? All right, I upload it here. All right, yeah. All right, so we have alternative logo design number 1. Yeah. And we have alternative logo number 2. We have we have more. We have alternative logo number 3. And that's, that's definitely a choice. A choice is being made in that. You can't see the logo in the top left corner of the screen. You can't see the logo in the top left corner of the screen. You guys can't see the logo? Okay. Well, then the whole thing's pointless. Never mind. Well, that was an interesting thought. Never mind. Well, so much for that fun. Oh well. Never mind. Just make it larger. I actually can't make it any larger. It is what it is. I can't make it any larger within the setup because all the things are set up by the interface. I can't make it any larger. I can't make any of the windows. I can't change the sizes of the windows. I can't change the sizes of the things. It's kind of annoying. One of the disadvantages of browser-based streaming. Someone in chat says the first one looked like the Pornhub logo. No, really? No way. Wow, what a weird thing. That didn't occur to me. Ugh. I might make the uncivil logo Pornhub logo thing on the back display too, because that sounds pretty hilarious. Not everyone knows the Pornhub logo. Uh-huh, sure. Sure. Yeah, let's go with that. Yeah. Next thing you know, someone else is going to say the other logo kind of looks like the OnlyFans logo. Wow. What a weird coincidence. What are the odds? Have I seen the Goes Wrong show, A Trial to Wash? No, I can't say I have. Where's the logo of Bev? Just run the. Where's the one with Bev? I know you created one. I can't find it in the chat. I've got Proctor, Yannetti, Jackson, Alessi, John O'Keefe, Sham Burgess, Hankey, Trooper Paul. I need Bev too. What's the most egregious error so far? Bringing the case? Yeah. You create that one? Oh, okay, Miss Mandy Rex. Would you be so kind as to dump it back in general then so that I can upload it to the thing behind me, please? Could you upload the one for that in general, please? I'd appreciate it. We also had this image produced by somebody, which I don't know what this means, but you know, someone will have to explain the joke to me because, of course, I have absolutely no idea what the joke is. I have absolutely no knowledge in any way what this could possibly be referring to. But It's 9 a.m. on the East Coast, baby. Let's do this thing. I'm a professional, guys. I'm a professional streamer. Bev said they'd start late today. What time are they starting? Do I get to go back to bed? They missed super chat. Okay, let's see. Jules gave $2. Said, did Alessi cross it to death or Commonwealth bored to death? I don't know. A little bit of both, I guess. Thanks for your super chat. What time are they starting today? Do I get to go back to bed? No clue. Okay, well, Jing quota time. All right. Well, that's completely unhelpful. A little later. What does that mean? See staff chat. Okay. First Amendment ruling out New Hampshire says a bakery can keep their sign even though the town had decided it violated code. Okay. Pretty banal First Amendment issue, but I guess. I mean, for lack of anything else to discuss. Vinny at 4 p.m. today. Well, as soon as the court day is over, whenever that is, it's tentatively scheduled. Look up. I am looking up. What do you want? I can't. My eyes. I'm reading different things in different places, Miss Mandy. Civil filing against Judge Bev. Where do you want me to look it up? Just dump it. Dump it. The last thing in chat. If you want me to see something, just dump it. The last thing in chat. Don't make me look for it, please. What do you want me to look at? Just let me know what you want, please. This is from April. We covered this long ago. This is the seeking suit in the federal court. This is from April 1st. This is old news. There's nothing there to talk about. You voted for Kurt 6 times in the 2032 presidential election? Thank you. Someone said it started at 10? Okay. Well, I guess we'll just kill time till then. Kurt's pretty rude to the mods who run his channel. Okay. Noted. I mean, they dropped me a document that's from April 1st. It's like we've already talked about it. I just don't understand. It's also very early, and I didn't sleep it particularly well last night. Tell us a story about my favorite obscure Supreme Court ruling. Baker v. Carr is a classic one, dealing with Senate apportionment in Tennessee, because it was a case that broke 2 Supreme Court justices, killing one of them because of the controversy relating to the case, the stress relating to the case. Do I drink coffee? Sometimes. So Baker v. Carr was a fairly famous case. The legislature of Tennessee had split the way they did their House and Senate. In the United States Congress, as I'm sure you're aware, the House is chosen by population, but the Senate is 2 senators per state, regardless of size. So Tennessee basically kind of cloned to that. Tennessee had its House apportioned by population, but it was 1 senator per county, I believe, if memory serves correctly, right? And Tennessee's argument basically was like, well, we copied basically what the United States Congress did, right? We copied their layout, And then the people who sued said, well, 1 person, 1 vote, right? This breaks the principle of 1 person, 1 vote. So that became a huge deal, as you would expect. And because of its obvious political ramifications, the Supreme Court was very reluctant to get into it at all, because, they were basically, to their own mind, wading into the political thicket. And so there was, it was a real challenge for the Supreme Court and some of the members on the Supreme Court at the time, because they're like, do we really want to get involved in this? Because we're doing something that has obvious and dramatic political overtones, right? This isn't just like, is a law valid or not? This is the entire legislature of Tennessee valid? Which, that's a lot. So that was a huge thing. And it basically, the stress of it killed 1 Supreme Court justice and drove another Supreme Court justice basically crazy. So it basically had two fatalities in the Supreme Court because of how stressful the case was for the political ramifications of it. Ultimately, the U.S. Supreme Court decided that 1 person, 1 vote was the rule. And so they said that basically the compromise that the U.S. system represented was basically a particular and peculiar compromise of federalism, that the logic of which basically didn't extend to the states. So at the end result of which was the states had to apportion both their own House and own Senate by population. They didn't necessarily have to do it the same way. So they could be based on different populations. They could be based on different sizes of populations, right? So it's not, so like, for example, you could have, it doesn't really matter. You could have any arbitrary number you want. You could have, 21 members of the Senate and 100 members of the House. You could have any arbitrary number, but those numbers had to be equal population. So every one of those 100 members in the House had to represent 1/100th of the population, and every one of the 21 members of the Senate had to represent 1/21st of the population. So basically it had to be even apportionment, which is still the rule today. But it's not one of the well-known cases, and it was the Chief Justice at the time, which was Berger, I believe. When he was close, maybe he had retired. I forget if he retired before he died, but yeah, I'm pretty sure it was Chief Justice Berger at the time was asked, like, what was the most important case of your career as a Supreme Court justice? And he said Baker v. Carr. Mind you, this is a guy who was on the bench when they decided cases like, Brown versus Board of Education, and minor cases like that. And he said the most important case of his career was Baker versus Carr. So there's a little Supreme Court history for you.
All right, could I see counsel at sidebar, please?
Sidebar. And it is also sort of looked back on as the first case in which the Supreme Court really laid into the political thicket. It's seen as sort of in the same way as Marbury versus Madison was a huge deal, because it basically gave the Supreme Court the power to decide what the law is. Baker versus Carr is looked at by Supreme Court scholars as basically the first case where the Supreme Court really weighed into political issues. Because, it wasn't just, is this law valid? But again, like, is the entire legislature of Tennessee valid? And I guess I was thinking of that case, at least in part, because the Supreme Court just granted an emergency injunction requiring the legislature of Maine to allow one of its people to speak, one of its elected representatives. So the legislature of Maine, the House, I think, of Maine, the House of Maine had censured one of its own members for speech outside of the House relating to LGBTQ issues, I think. And like, they were so mad at what this person said, when they weren't, in the chambers. They were so mad at their speech that the House of Maine, struck them from committees and took away their speaking privileges on the floor of the House. And the U.S. Supreme Court yesterday issued an injunction requiring the House to allow her to speak. So I guess that was one of the reasons it was in my head. And so if you want to know the root of that decision, Baker v. Carr, baby, it's where it all goes down to. And then two justices dissented, which was, I thought, really interesting, because Jackson and Kagan, I think, dissented, although Jackson, I think, wrote it. Jackson dissented basically because she thought it was interesting, because you think Jackson would go for it, but she didn't really write about the merits of the decision so much as she was mad at the Supreme Court granting emergency relief. She thought that the Supreme Court has been too loose recently granting emergency relief. And so she was chiding the Supreme Court for granting relief on such an expeditious basis. So that was an interesting dissent by Justice Jackson. So, yeah. I could have really used a couple other hours of sleep. I'll tell you what, man. I may need to take a nap.
Let's bring the jurors in, please.
Leave it for now. If I fall asleep on stream, please forgive me.
All right, so the court, jurors entering.
Someone better make Spinny Fan spin. I tell you what. Someone better turn on Spinny Fan, or I'm going up there myself and turning it on. I swear. Can we send someone into the courtroom to turn on Spinny Fan, please? Do I have to file an emergency petition with the court or something? Emergency petition in Ray Spinny Fan.
Please be seated.
Good morning, jurors. So, an issue has come to my attention that is going to make
What the hell is this? Okay, you've got my attention.
it necessary that I talk to each one of you individually over at sidebar with counsel. So that process will take a little while. So I'm
What the fuck is this? What the fuck is happening? Holy shit.
going to don't speculate as to what I'm going to talk to you about. Please, when you go back to the deliberation room, talk about anything but this case, and I'll see each of you individually. And the process may take. The cameras will be shut off, and I'm going to talk to the lawyers about whether we clear the court. No filming. All right, send you back, and we'll send you back to the individual.
Shenanigans. Shenanigans are happening. Shenanigans are happening. We're going to talk to each of the jurors individually. There are 18 jurors. This is going to take a hot minute, guys. This is going to take a really hot minute. We need something else to do while we're waiting, because we're going to be here for a while. I don't know what's going on, obviously, but you could only speculate, but someone has a concern about the jurors and something, whatever. Holy shit, dude. What the fuck is going on this morning? Okay, good times. Check email? No, that's okay. Just tell me. I'm a little busy right now. Shit show? Yeah. Take a nap? I mean, yeah, sure. Could be. Are we still on schedule? I don't know about that, man. I don't know that we're still on schedule. She knew it would happen. That's why she didn't tell the witnesses to come in until later. Yeah, that kind of makes sense. Yeah, makes sense. This came to her attention like last night or something. Someone on the jury matched with Bev on Tinder. There you go. Could be that. Well, on the plus side, I have plenty of time to update the thing behind me. So I guess I'll do that while I'm waiting. I blame Spinny Fan for not turning. That is definitely what's happening. That's fair. I mean, Spinny Fan isn't spinning and everything goes to hell. That tracks. That 100% tracks. Wrong answers only, chat. What do you got? Wrong answers only. We'll read some of your suggestions about what is happening in the courtroom on screen, or I'll read them aloud or something. How many jurors are required? 12. They've got 18. So if it's just impacting like a juror, it shouldn't be that big a deal. Should check in with light fixture. I heard a rumor that a juror told a bailiff that Bev sustains too much and they just want to hear what they have to say. I heard that rumor too, actually. That'd be funny if that's what's going on. That'd be funny. It's like, yeah, this is irritating me. The jury has notes, and the Bev is not about to be. Jury's not about to be here for notes. Bev is inviting them to the barbecue this weekend. Could be. With great Spinny Fan comes great responsibility. Facts. Proctor admitted to murdering him. That makes sense. I could do more watch shopping. I could. At the moment, I'm back to my Citizen Titanium for the moment. Took off that stainless steel one. So I'm back to my solar. She wants to know where she can get some uncivil law merch. All the coolest judges do. It's the new black robes. Bev and the lawyers are looking for a better expert than Shannon from among the jury. I think the odds of finding a better expert among the jury are pretty decent. Yeah, it seems pretty good. Bev found out that Shannon wasn't even employed by Aperture. Yep. They ordered D&E pizza so they could get the full Canton experience. Some of the jurors had AirPods in during the case. That'd be good. The prosecutor cried in Bev's arms. Yep. The jurors are making signals too. The juror maybe came in singing the OnlyFans song. That'd be good. That'd be good. Yeah, they started singing. Spins round and round, turn again. 34 Fairview found a man lying in the snow. Only the McGilberts know. Yeah, I buy that. Bev needs to change the wagers she made online. Bev found out one of the jurors listens to Nickelback. Look at this photograph. Every time it makes me laugh. Bev wants to know where she can get a nice watch. Well, although it's a little cliche, women's watches are dominated by Cartier. So, I mean, it's hard to go wrong recommending Cartier to a woman. First of all, Cartier makes excellent watches. Their in-house movements are amongst the best. They're second in Switzerland right now, I think. They might be third. I forget if Omega's second or third, but they're right up there with Omega for second place behind Rolex. So if you're shopping for a woman, it's hard not to just start with Cartier as a recommendation. Of course, you could always go with one of the smaller size Rolexes, like a 36 millimeter Datejust or something like that. I mean, it works and it's beautiful. So those, Cartier tank and a 36 millimeter Datejust, and you kind of go from there. It's interesting. It's interesting because women tend to dominate in jewelry, generally speaking, obviously, but watches is much more man dominated than women dominated, which is interesting. So I guess men have that little bit of jewelry for them. We dominate the market by far. So that's nice. Are there poly bet marks on this case? There are, in fact, poly market bets on this case. There are poly market bets, and it's hilarious. Apparently, the media has been expelled from the courtroom. That's hilarious. The entire media has been expelled from the courtroom. Apparently, the entire courtroom has been cleared. Apparently, the entire floor has been cleared. It's getting interesting and rough out there. Cartiers are insanely overpriced. I don't know that I'd agree that they're insanely overpriced, although they are expensive. But Cartier does make really good movements, and they are a really well designed watch. So I certainly agree that Cartier is expensive. I don't know if they're insanely expensive. You are getting a lot of watch to be fair to Cartier, but I mean from a mechanical design perspective. From the engineering perspective, there's a lot of watch inside Cartier. Cartier is one of the best in terms of their design and engineering. They're right up there. But they are expensive. They are expensive. Nate was looking at a Cartier Santos the other day. I went with him to the store, and he was looking at a Cartier Santos, $7,500. I was like, yeah, I mean, it's a great watch for a man's watch. I mean, it's a nice alternative to a Rolex. It's especially if you like if you want a square design. So I mean, but it is a lot of watch, but yeah, I mean, the Cartier tank is classic. Jury was watching on civil. Yep. Jurors are all extended family members of the McAlberts. At this point, I believe it. Read the deportation decision. Was that the one that they removed the status? I think we discussed it briefly yesterday. Santos has history as the first pilot's watch. In a very technical sense, that's true. Yes, in a very technical sense, yes, it is the first pilot's watch. Yeah. In a technically correct is the best kind of correct, yes. Yeah. It doesn't look anything like what you'd consider a pilot's watch today, but yes, I think it was. Yeah, it was. Yeah. What's my thoughts on the Sky Dweller? Not a fan. I don't like the design personally. I find it way too busy for me. Yeah, I am not a Sky Dweller fan. Pass. If it speaks to you, it speaks to you. It's just not for me. I find it busy and not in a good way. Like there are busy dials that I don't mind, but I don't like the way that the Sky Dweller is designed. It is not for me. Chloe returned from witness protections, ratting on everyone. It's about deportations that happened yesterday. All right, post it again in staff chat then, and I'll bring it up. 5, Louis Vuitton. Louis Vuitton is not a watchmaker. Louis Vuitton are posers. 3 tags. Depending on which tags, yeah. Patek Philippe. Patek Philippe, obviously, there's some good ones out there. But I'm still Ace Long or Journe over Patek Philippe or AP. That's my hot take. That's my hot take. Give me a Ace Long or a Journe over an AP or a Patek Philippe. %60 guilty on Polymarket? Really? As of this morning? They must have changed a lot since yesterday. Damn. It wasn't that high yesterday. Let's see. Yeah. Wow. I mean, the odds went up huge yesterday. I mean, it spiked like crazy yesterday. I don't know what that's all about, but I mean, facts. I mean, yeah, Polymarket went like crazy yesterday. It was down at 14 cents and then it went up to 60 cents. That's like a huge jump. That's a lot. Damn. I'm not sure what that's all about, but shit. I don't understand that at all. The odds of acquitting, however, are remaining relatively stable, which is kind of hilarious, which doesn't make any sense. But, okay. She wants to know if any of them know Kurt from Uncivil Law. Maybe. I did not get a call from the court, or at least not one that I answered. She found out that one of the jurors already made their own YouTube channel together with making fun of the witnesses. That'd be good. Does that technically defy the court's order? I guess it probably does, but meh. Yeah, cameras are off. Everyone's been kicked out of the courtroom. Deportations for South Sudan. We can read this in a second. One of the jurors kills Spinney? Maybe. Reed cleared out of the courtroom? That is not possible. It is not possible that Reed was kicked out of the courtroom. She's the defendant. She's entitled to be there for all proceedings. It is not possible that Reed was kicked out. That would be that. Yeah, no. Yeah, the deportation happened yesterday. I'll talk about it. Thank you, Kestrel. One of the jurors got caught watching microdots. Yeah. She questioned them by herself in the presence of the lawyers. She can. Yeah, but the lawyers are obviously able to be there and observe it. But she can direct questioning, depending on what's being investigated. Sure. But the idea that Reed wouldn't be there, that seems impossible. It would have to be like, for Reed to be kicked out, it would have to be like, I don't even know what that would be. It would have to be something really weird if Reed wasn't allowed to be there. Yeah. Bev has cleared the courtroom and the second floor of the court. Only the jurors, attorneys, and Karen are allowed to be there. That makes sense. A woman's Rolex? Yeah, a woman's Rolex would be fine. They make 26s as well? Yeah, sure. Yeah, a woman's Rolex would be perfectly fine. Nothing wrong with a Rolex. They hold their value very well too. They're beautiful, classic, reliable, durable. You know, they're number one for a reason. They hold their value well. No one looks down on a Rolex. No one's gonna look down on it. We're losing watchers. Okay, well, Kestrel, what do you want me to do about it? What do you want me to do about the fact we're losing watchers? How do you want me to keep the watchers engaged? What do you want me to do? I'll do it. What do you want me to do? Dance? I'll dance if it will keep the subscriber count going. I'll tell you what, man. We can dance if we want to, leave the world behind. If we don't dance and if they don't dance, then they're no friends of mine. S S S S A A A A F F F F E E E E T E E E Y I I A safety dance. Your budget allows Timex or Seiko? No disrespect though. And Timex is making some interesting stuff these days. Their Q line is interesting. The Timex Marlin is interesting. Timex is making some interesting stuff these days. So there's some choices for Timex that I would not look down on at all. Seiko isn't quite the cost savings it used to be. Seiko still makes good stuff, but their cost for value ratio isn't quite as good as it used to be. Take another look at Citizen watches. I really feel like Citizen has, to a large degree, taken the place of Seiko in the value proposition. Citizen, I also feel like Citizen is not quite the mall watch that they used to be. They've gained a little reputation. They've gained a little horological reputation, and their value performance is really good, like compared to Seiko. I think that Seiko makes some great stuff. Seiko makes stuff at every price point, though. That's one thing that's good and bad about Seiko. Seiko makes something at every price point. They make something that's $250, and they make something that's $50,000. So, do you want to spend $250 or do you want to spend $50,000? Seiko's got you covered. They've got all the options. So that Seiko's got that going for them. What's my opinion on MVMT watches? Trash. Absolute trash. 100% trash. MVMT is trash. Trash watches. Along with Daniel Wellington, absolute trash. Garbage. Garbage watches. Trash. Fossil, I don't really like their watches. Fossil, yeah, no. They're trash adjacent. They're one step above trash. But you know, they're not great either. Swatch is different. Swatch is different because like Swatch is what it's always been. Swatch is very unpretentious. Swatch was literally called Swatch because it was named second watch. That's why it's called Swatch. It was designed to be like cheap and somewhat disposable and just kind of fun. And also the Swatch Group owns everybody. So there's that. Omega is really cool. Omega, especially with their master chronometers, very cool. They just came out with the new Railmaster like yesterday or the day before. Very cool. The Omega Aquaterra is a fantastic all-purpose watch. Omegas are also quite a bit cheaper than Rolex. I mean, like half the cost of a Rolex. You can also actually buy one. That's nice. The master chronometers are, magnet proof. You could take one into an MRI and it would work. I don't really like the Moon watch. I also don't like a mechanical wind. If I wanted a chronograph, I'd either get a automatic version or probably get like a Zenith or something, or a Daytona if I could afford it would be nice. But not a Moon watch. Not for me. But the Aquaterra I would buy and wear. That is a very, very cool watch. G-Shocks. G-Shocks are cool. I've got a G-Shock. They're great. They never die. Jacob and Company. No, they're too pretentious. Similar feelings to Richard Mille. It's like I find them way too like they're trying too hard. Zenith, however, has great history. Its El Primero is fantastic. Its Lunar Pilot is really good. Zenith lately seems to be moving in a Hublot direction, which, please don't do that ever. Don't be Hublot. Don't be those guys. Also, Hublot is trash. The James Bond Omega from Crescendo Real is beautiful. Yeah. They're very cool. There are Richard Milles with happy faces on them for $500,000. I am well aware. I am well aware. I don't get it. I don't understand what people are paying for. I don't understand. Yeah, I don't. When you're spending $300,000 on a Richard Mille, I don't understand. I don't understand how that's $300,000 of watch. I don't get it. I don't know. It doesn't make sense. Tudor's really cool. The new Pelagos Ultra caught my eye. 43 millimeter, 1,000 meter water resistant, adjustable on the fly, toolless adjustable band, plus it's spring loaded as well for a wetsuit. Very cool. That Tudor Pelagos Ultra in titanium. It's calling my name. It says uncivil, buy me. And I say, Tudor, I don't have $6,000. Buy me. I'm beautiful. I'm all the watch you will ever need, ever. I have 1,000 meters of water resistance. I'm a master chronometer. I can go inside an MRI and I'll still work. I can go to 1,000 meters. I have a helium escape valve. I have micro adjustments. I have a spring loaded band. I'm a tool watch. You can beat the shit out of me and I will still work. You can beat the absolute crap out of me and I will still work. And then having beat the absolute shit out of me with all the scars that are apportioned to me, you can also wear me with a tux and people will love you. Buy me, says the Pelagos Ultra. And I'm like, damn it. Fuck. Patek Philippe ancient antique watch? Sure, why not? Patek Philippe is a good watch, along with AP. Although an AP is just a Royal Oak these days. Do they make anything else? But I mean, Patek Philippe is fine. I mean, it's a great Swiss brand. If you want to spend, 5, 6 figures, it's, it is what it is. But, you know, watches are worth the splurge. They can be, depending on what you're trying to do with them. I mean, I love watches. I like this watch I'm wearing right now. This is $400, and I like it very much. This is a watch I've talked about before. It's the Citizen Pro Master Tough Ray mirrors. It's a 40 millimeter titanium sapphire crystal, very legible, as you can see. Monoblock titanium, 200-meter water resistant, shock resistant. If I were graduating like boot camp, as a young 18-year-old and looking for my first watch, I think this is the one I would buy. It's solar. It will run for 6 months in the dark. It's quartz, so it will always keep accurate time. And it's shock resistant, titanium. It's lightweight. It's durable. You can jump out of planes with it, and this is the new Navy SEAL watch. I'm telling you, this is the new watch for Navy SEALs. Yeah, this is the way to go, man. Durable, reliable, rugged, shock resistant. This is the watch, man. $400, fantastic. Nico Leonard is a fun watch channel. Yeah. Solar flare resistant. It's all that too. And it's magnet resistant, although it's not as magnetic resistant as the master chronometer. I think it's only rated to something like 4,000 Gauss or something like that, or 5,000 Gauss. So it's not quite MRI territory, but the Mill Gauss, when it was first invented, the Rolex Mill Gauss, which is probably the first I don't know if it was the first magnetic resistant watch. It might have been, actually. The Rolex Mill Gauss. You know why it's called the Mill Gauss? Take a guess. Why do you think it's called the Mill Gauss? Why do you think the Rolex Mill Gauss is called the Mill Gauss? Anyone got any hints? Or do you need me to spell it out? For those of you not picking up what I'm laying down, it was called the Mill Gauss because it was resistant to 1,000 Gauss. Ooh, right? Yeah, that's why it was called the Mill Gauss. It's because it was resistant to 1,000 Gauss, right? So when the Mill Gauss was first invented, that was like the first magnetic resistant watch. This is rated, I think, to something like 4,000 Gauss. And MRI is like 12,000 Gauss. So this isn't quite MRI resistant, but anything in the real world, it'll be fine. Mil meaning thousand? Yeah. Like millimeter? Yeah. Like million? Right? Why is a million called million? Right? Why is a million called million? Because it's 1,000. 1,000 thousands. A million. Exciting, right? The more you language and you, the more you know. The more you know. Yeah. I'm here to help. What are my thoughts on the Rolex Deep Sea? 100% approve. 100% approve. Also the Sea Dweller. 100% approve. The only thing not to like is the thickness of the case. But if you can get past that, 100%. Yeah, the Sea Dweller or the deep ocean or the deep sea, 100% sold every day of the week. Yeah, the only thing not to like is the thickness of it. But if you're okay with, because it has to go deep, so it's thick. So as long as you can get past that, yeah, easy every time. Let's look at watches together, you and me. This 160,000 Gauss resistant Omega watch. What the hell? I didn't even know numbers go that big. What the fuck? Hold on. That time Omega tested a prototype Seamaster at an insane 160,000 Gauss magnetic field. What the fuck? Just because we can. Omega actually tested a watch, a prototype of the Seamaster Aquaterra, to 160,000 Gauss. And believe it or not, it survived and is now at the Omega Museum. Where are you coming into contact with 160,000 Gauss? Or for that matter, where are you coming into contact with even 15,000 Gauss? An MRI is only 12,000 Gauss. Where are you coming? You could wear an Omega Seamaster or an Omega Aquaterra inside an MRI because they're resistant to that level of magnet. You could wear an Aquaterra inside a goddamn MRI. What situation do you need 160,000 Gauss for? Who is this for? The high-intensity experiments took place in 2016 at Laboratoire Nationale du Champ Magniques Intense at France. The timepiece functioned perfectly and after exposure to that. Okay. Noted. So I guess Omega, because we can. I guess Omega, because we can, prototyped 160,000 Gauss watch. Noted. Yeah, I mean, yeah, right? I was like, how much do we need, man? How much do we need? Right? Again, this watch is like 4,000 Gauss. That's a lot of Gauss, right? That is a lot of Gauss. 4,000 Gauss is a lot of Gauss. Where am I coming in contact with 4,000 Gauss, right? If I needed more than that, if I needed to, be inside the room with the MRI, then I guess I'll get myself the Aquaterra. But it's like, I don't know, man, what we're doing here. I'm looking great, kicking butt. Thank you. I appreciate that's very kind of you. Yeah, just a regular nurse's watch here. Yeah. I like it. I like it. It's just like, really? Yeah, but back in 2013, Omega came out with the 15,000 Gauss watch, which is now standard for their master chronometers. So it was, now you can just buy it. A watch for Magneto, I guess. A black hole. There you go. There you go. That'll do it. Self-winding, flying, tourbillon, extra thin. That sounds like a lot of money. Omega Dark Side of the Moon. Respect. Let's take a look at some of the watches that you guys like together. We'll take a look at some of the movements you like. Omega Dark Side of the Moon. Yeah, I mean, fair enough. You got these two. This is interesting. So you got this one. I mean, that's cool. It's manual winding though, so that would drive me a little crazy. Yeah, the manual winding aspect of it would drive me a little crazy. That means you actually have to wind it every day, which is kind of annoying, or every like 3 days technically, but still. I believe this one is automatic though. Yeah, this is an automatic. So yeah, this would be like more my speed. Get an automatic Speedmaster. They're back. No, they're really not. Still not fan. But yeah, I could definitely go for this. Although at this price point, $13,000, I don't, yeah, I mean, it's a little pricey for my taste. The one they just came out with yesterday, the new Railmaster. Where is it on their website? Yeah, here it is. The new Railmaster just came out yesterday. That's pretty cool. That is very, very cool. I like that watch a lot. It's a 38 millimeter, so it's a little small for my personal taste. I really don't want anything under 40 millimeter. Preferably 42 would be nice. 38's a little small for me. So, but I like the design a lot. I wish it was a little bigger. I personally also really like the seconds at the 6 o'clock position. That's called a small seconds complication. When you have the seconds at the 6 o'clock position in a subdial, I also really like that look. So I am definitely like on the hunt for a small seconds watch. I was looking at the Aquaterra small seconds for that reason, because I think it's cool and I don't really need a reason beyond that. Yeah, like this one here. $7,200. That's cool. 41 millimeter. Very cool. That definitely is on my list of possible watches. You don't like the small seconds? See, this is why they make different watches for different people, Tony. But it comes in a variety of colors. Here's one in gray. If you want something a little bit more plain, here's one in green or like a darker gray. I don't like that way that second hand looks on that particular one, though. All right, what else do we want to look at? Start reviewing Walmart watches. You could get if you want just like something super basic, just get like at Walmart, you could get a Casio Duro. Here's something you can buy at Walmart. The Casio Duro. $70 retail, you get a little bit cheaper than that at Walmart. 200 meter water resistant, analog quartz, basic, tried and true. $50. It's available on Amazon for less than that, actually. There you go. $44 from Amazon. The Casio Duro. It's well respected in the watch community. People like it. It's basic, but it works. 200 meter water resistant. Durable. It's a fine watch. $50. What's not to love? Do that. There's a Walmart watch for you. There's your Walmart recommendation. Buy that. Put up a status banner? Fair enough. Let's put up a status banner. Do this banner that way, this way, so it makes it easier. The Nikon Siron is $125. Let's take a look at it. For $125, though, I feel like you can't really go wrong. If you like it for $125, buy it. It would be my thought. What's the worst that could happen? But let's take a look at this thing. An essential Tide watch with both style and substance. Okay. Basic Tide functionality and soft silicon band means stays in and out of the water. Okay. 100 meter water resistant. There you go. Digital module with basic Tide. Functions include time of day, date calendar through 2099, basic Tide, future Tide, EL backlight chronograph, customizable timer. Sure. If it speaks to you, go for it. Why not? If it speaks to you, go for it. $125. 100 meter water resistant. That's sufficient for, basically anything that you'd ever do. You could take it into the ocean easily. You could kind of do anything with it. Yeah, sure. Why not? Yeah, if you like the look of it, it's a digital watch, obviously. Of course, the ultimate digital watch. So this one Yeah. The ultimate digital watch is this. The A Long and Song, A Lang Sang. I can never pronounce their name correctly. But this is the ultimate digital watch. There's Zertwerk. It's got that small seconds, though, that Tony doesn't like. Discord. Okay. So that watch can be yours. How much are they going for these days? Oh, this one's, yeah, here's one that's $54,000. Oh, that's not so bad. Yeah, okay, so I can get a used one for $55,000. Okay, yeah, so that's the ultimate digital watch. So if you have $55,000 floating around for a used one, yeah, here's one in platinum for $279. Here's one for $95, $51,000, $99,000. Yeah, so if you got, is it both digital and analog? It is technically a digital watch because it has digits. See, so it has digits. You can see them, right? Because it's 1007. It's digital. Because it has digits. It's digital. It's yeah. It is a digital watch. Yeah, I mean technically. It's mechanical. It's a mechanical digital watch. Yeah, that's what it is. It's a mechanical digital watch. What's the dial at top? Power reserve for the spring. That's the dial at top is the power reserve for the spring. Yeah. Good times. What else do we want to look at? Yeah, that's why you asked. No problem, Rose. I'm here to help. Thank you, by the way, for the 435 of you who are spending time with me. I do appreciate it. What are these watches that you sent me, Afix? What are these things? $9 million. What the fuck is this? Grand Complication in diamond. What a gaudy monstrosity, though. Holy shit, though. I mean, okay. I mean, that's a choice of some kind. Here's one with rainbow. It's only 6 million. $1 million for a Patek Philippe Nautilus? What's it made out of? Tiffany and Company? Get $1 million for Tiffany? Patek Philippe? I know they're rare, but damn, still, really? Is that what they're going for these days? $1.5 million? Shit, it's gone up since last time I noticed. Is that really what they're trading for? Holy shit. If you want that Tiffany, I guess, man, shit. I mean, all right. 1.4 million for Richard Mille. You'd have to be out of your mind. 900,000 for Richard Mille. You'd still have to be out of your mind. All right, let's take a look at this case someone sent me so we can learn something of legal value. $9 million, yet Shannon would tell you it's not accurate. Well, Shannon would actually be right. I mean, it's probably not particularly accurate. I mean, compared to some other alternatives. You know, if you want like the most accurate watches in the world, then you're probably not looking at mechanical at all. Like because even like decent, good quality mechanicals, you might get plus or minus 2 seconds. But even like what's it called, the certification, the Swiss certification, not Metis, the other one. Even that's like only plus or minus 5 seconds a day. But if you want if you want accurate, like any quartz watch will basically beat the accuracy of basically every mechanical watch. The cheapest quartz will beat the accuracy of like pretty much the most expensive mechanical watches that are made. So the spring drive is quartz though. It's quartz with extra steps. But the oscillator is quartz. The movement is mechanical, but the oscillator is quartz. So it's a quartz with extra steps. And its accurate is to about the same thing, about a second a day, give or take. Although they have the new ultra fine accuracy, which are about twice as accurate as that. COSC, thank you. COSC certification was the one I was looking for. Yeah, if you want like the ultra accurate stuff, like Citizen made the most accurate watch that's ever been made, to the best of my knowledge, is the Citizen Caliber 0100. It's accurate to a second a year. So if you want the most accurate watch ever made, yeah, this is the most accurate watch ever made, to the best of my knowledge. The Citizen Caliber 0100. It's light powered too. It works on the sun, and it has an annual accuracy of plus or minus 1 second. So this is the most accurate watch made. So if accuracy is your thing, this is as good as it gets. I think it's like 36 millimeter though. 37 millimeter. So it's 37 millimeter. So it's a little small for me, but there you go. I think it runs about, I think it's under $10,000 though. So that's plus. Why get that accurate? Well, because you can is sort of the reason. Because of the engineering accomplishment, right? That's kind of the reason that mechanical watches are valued at all. Like, why buy a mechanical watch at all? And the sort of the reason is because of the engineering craftsmanship, right? Because you like the mechanical aspect of it because of the engineering. And so this is a quartz watch, but kind of the same reason. It's like, because of its accomplishment, because it's there. The same reason that people buy watches with an incredibly long power reserve. The same reason that people buy watches that, just because you can. Because you can goes a long way. Atomic watches? No, you see, there are no atomic watches as such. There are atomic watches that are radio or GPS controlled, and those are quite a lot cheaper. This watch is not externally controlled. It is completely self-controlled. So it is the most accurate watch that's made that's not using an external regulator. Because I have a G-Shock on my stand, $100, that is radio controlled. So every single day it resets itself using the atomic clock. It picks up the radio signal, and every single day it resets itself. So that watch is always dead on balls accurate every single day. But it is using an external reference to do that. This watch is not using an external reference. It is using its own internal mechanisms. If they actually made an atomic wristwatch, that'd be badass. I'm not sure if that's technically possible, but that'd be cool as shit. You say you've got a G-spot? Ha 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 ha. Cute. Very cute. Let's read this other case. All right, so this is dealing with some deportation order, which I don't really know anything about, but let's read it anyway. So this is from the United States District Court, District of Massachusetts, in the case of DVD versus Homeland Security. This case presents a simple question. Before the United States forcibly sends someone to a country other than their country of origin, must that person be told where they're going and be given a chance to tell the United States if they might be killed if sent there? That is fairly loadedly phrased, federal court. Yeah. Defendants argue that the United States may send a deportable alien to a country not of their origin, not where an immigration judge is ordered, where they may be immediately tortured and killed. Again, this feels pretty loaded by the district court. This language, I'm skeptical of this decision immediately just because of how it's written. Right? I don't know whether the judge is right or not, but the language they're choosing is very charged. It's very charged language, And so I'm immediately skeptical of it because of how it's written. Casio has an atomic clock? Sure. Yeah, Casio does. Seiko does. Citizen does. Yeah, Casio's G-Shock. Yeah, my G-Shock is atomic. It's a GWM 5610. It's atomic. Casio G-Shock. GWM 5610. It's $100 on Amazon. 200 meters water resistant, atomic controlled, solar powered. Fantastic. Another good choice for our friends in the military, incidentally, because, it has a stopwatch and it has alarms and timers and all kinds of cool shit, which might be very practical for the field. And also is very rugged and durable and, takes a hell of a beating. So the 5610 is a very good choice for our friends in the military as well. So if you don't mind the digital watch aesthetic, but you get more functionality with it, which is nice. Anyways, pressing on. All 9 sitting justices of the Supreme Court of the United States, the Assistant Solicitor General of the United States, Congress, common sense, basic decency, and this court all disagree. Plaintiffs are seeking a limited and measured remedy. One, defendants have conceded other proceeding is the minimum that comports with due process. Plaintiffs are simply being asked to told they're going to be deported to a new country before they're taken to such a country, and given an opportunity to explain why such a deportation will likely result in their persecution, torture, and death. This small modicum of process is mandated by the Constitution. I'm having a very hard time taking this decision seriously because of how it's written. This is just written very, very activist, right? I'm having a very hard time taking this decision seriously because of how it's written, which maybe is a weakness on my part, but I'm just telling you. I can't. I'm not even sure I can be bothered to read it because of how it's written. It immediately puts me off because of how it was written. It's please, you know what I could do? Let me ask ChatGPT to rewrite it, and that way I can give it a fairer glance. Let's ask ChatGPT to rewrite this in a more neutral way, and we'll give that a shot and see if we can make that work. Is it hyperbolic? It's something, man. It's just written in a very, yeah, we can do better, man. All right, let's add a file here. Let's add this document that we just downloaded from the court. All right. Please, all right, let's say, please rewrite this judicial decision to be less activist and more neutral. If possible, rewrite using originalism. All right, yeah, let's see what we can do with this. Can you guys see this? Yes, you can. Okay, good. What if it changes the decision? I don't know. I'm just trying to give it a fair shot. I'm having trouble reading it the way it's written. So this is me attempting to give it a fair shot. If it changes the decision, I don't know, man. I'm just trying to give the decision a fair shot. The decision immediately makes me want to punch it in the face. You know? This is like, can you please tone this the fuck down? Could they bring in a chessboard? Yeah, sure, why not? ChatGPT currently taking its sweet ass time. Maybe it got hung. Sometimes it gets sometimes it hangs. Let's see if it finished in a different window. I don't know. Okay. Rewritten opinion text. All right, what the hell is this? Okay, it tried. Okay, it rewrote it in text. All right, let's give it a shot. Let's give it a shot. It rewrote it as a text document. Okay. United States District Court, DVD versus United States of Homeland Security by Murphy J. The Constitution supplies a simple guarantee. Before the government deprives any person of liberty, it must supply the notice and opportunity to be heard that the Due Process Clause of the Fifth Amendment has required since ratification. The present dispute concerns the application of that bedrock rule to removal of non-citizens to a nation that was never designated in their final order's removal. It's already significantly better. Already, I am approaching this in a much better way. Thank God. Plaintiffs are non-citizens who have either been or imminently will be removed to a third country that were not addressed in their immigration proceedings. They ask that prior to such removal, the Department of Homeland Security provide written notice identifying the proposed country of removal and a meaningful chance to assert claims for protection under statute and treaty, most prominently the mandatory bars to removal found in some code and in the Foreign Reforms and Restructuring Act. DHS contends no additional procedure is required. Already, I am a much happier camper. Applying the text, structure, and historical understanding of relevant provisions of the Immigration and Nationality Act and Fifth Amendment, the court concludes the plaintiffs are entitled to the modest preposterous they seek. Accordingly, for reasons that follow, the motion for class certification is granted, and the motion for preliminary injunction is granted in part. This is already massively better. The relevant law of the INA authorizes DHS to execute a final order of removal. Some subsection establishes an ordered hierarchy for selecting the destination country, and some other section categorically forbids removal to a country where non-citizens' life or freedom will be threatened. These words are mandatory, they admit of no discretion. Whereas here DHS seeks to remove an individual to a nation that was not selected by the immigration judge, and is not the individual's country's citizenship, the agency is acting under some subsection of law which allows removal to any country whose government will accept the alien. That residual clause neither displaces some other law nor abrogates the procedural minima inherent in due process. Nice. As founding, due process law was universally understood to require advance notice of government's intended action and fair opportunity to contest it before a neutral decision maker. Removal to a country where a non-citizen faces persecution or torture is a paradigmic deprivation of liberty. Because liberty at stake is grave and procedural burden of the government is light, the historical balance struck by due process clause requires DHS to provide notice and hearing request. Defendants invoke some law. These provisions channel or bar review only of challenges to the merits or execution of the removal order itself. Plaintiffs instead contest DHS's extra record designation of a new country of removal. See, I like this, right? Because there's like, okay, you can't challenge the removal order itself, but it's not in the removal order. So that's what we're challenging. We're challenging something outside the removal order. Okay. Plaintiffs instead contest DHS's extra record designation of the new country of removal, an issue of collateral to the validity of the underlying order. They therefore possess jurisdiction. The proposed class satisfies the relevant rules. It's numerous, presents common questions of law. The named plaintiffs are typical, and the government has acted on grounds applicable to the class as a whole. I mean, fair enough. I mean, I'm buying this. I'm buying this. You present this to me as a judge, I'm like, I'm buying this. This makes sense to me. You're speaking my language. Jesus Christ. For reasons already recounted, plaintiffs are likely to establish the removal to a third country without prior notice and opportunity to assert withholding. Claims violate relevant law and due process. Removal to a nation where one may face persecution and torture constitutes irreparable injury. The government cannot suffer harm from an injunction that merely ends unlawful practice. The public interest is served when executive action conforms to statutory and constitutional commands. Pending final relief, DHS shall furnish written notice of the intended country 21 days prior to transfer, afford non-citizen the opportunity within the period to assert claims. Removal may proceed only after those claims are adjudicated under existing regulations. The injunction applies to certified class. Because the relief enforces something as not contravene something else, no bond. Yeah, I mean, if you wrote this to me, I'm like, oh, that makes total sense. That makes total sense. I'm like, oh yeah, I understand all those things. Thank God. Thank you, ChatGPT, for saving us. Thank you, Jesus. The references, yeah, it's possible that the citations are not accurate. So it's possible the citations by Corchi but I asked it to rewrite what was there. So I'm assuming that it's less likely, and also assuming that it's just rewriting it in better language. So, but if that would make sense, and then I could go look at it. But at least I'm a happier camper. When did non-citizens have more rights than we do? They don't. Non-citizens do not have more rights than we do. What is your next question? You just shared on staff Discord. All 18 jurors are present. Media is still downstairs in the hallway. It's highly unlikely we'll get an explanation if testimony resumes as normal. True. Nobody except those in the courtroom knows what's going on, so any speculation is not true. Yeah, I mean, we'll probably learn if a juror was dismissed, but probably not anything else. I mean, not for at least the reasons that people can count. And so if there's a juror that's not there, then, people will put two and two together. So, yeah. We can go back to looking at watches, though, or we can look at other things. What else would you guys like to talk about? I'm here to serve you, the uncivilians. What do you guys want to talk about? We can talk about watches. We can talk about court decisions. We can talk about watches and court decisions. Yeah, those are the topics we can talk about. We could rewatch some of the testimony from yesterday, if you guys like. I mean, maybe we just didn't give Shannon a fair shot. Maybe we didn't give Shannon a fair shot. Maybe we should rewatch some of his testimony with a open and renewed eye. And, be like, maybe we judged him unfairly. We could rewatch some of his testimony if you guys like that. Most useless watch complication? Well, moon phase, probably, although they're beautiful. Can we talk about Morse versus Frederick? I'm not particularly familiar with that decision. Let's take a look. Or maybe I am, and I just don't know the case name. Oh, this is the Bong Hits for Jesus case? Yeah, I thought the Bong Hits for Jesus case was wrongly decided. Do you guys want to talk about the Bong Hits for Jesus case? Well, I mean, we can. I mean, that's, yeah. Yeah, let's take a quick look at Bong Hits for Jesus. Let's take a quick look. All right. This is the case of Morse versus Frederick, U.S. Supreme Court 2007. At a school-sanctioned and school-supervised event, petitioner Morse, the high school principal, saw students unfurl a banner stating, "Bong Hits for Jesus," which she regarded as promoting illegal drug use. Consistent with established school policy prohibiting such message at school events, Morse directed the students to take down the banner. When one of the students who brought the banner to the event, respondent Frederick, refused, Morse confiscated the banner and later suspended him. Now, I don't know whether or not the Supreme Court is going to discuss it. Presumably they are at some point. But as memory serves, Morse was 18 at the time and checked himself out of school because he was legally an adult. So he checked himself out of school for the day. So he was not attending the school event qua school event. He happened to be there at the same time the school was there, and he was a student at the school generally. But if memory serves correctly, Morse himself was 18 at the time, a legal adult at the time, checked himself out of school for the day, and was attending on his own, separate and apart from the school, if memory serves correctly. And that's sort of why I thought the decision was incorrect, because Morse was not attending, strictly speaking, a school event. That was the reason I thought the decision was wrong. So I don't know if they're going to get into that, but that was a big factor. The school superintendent upheld the suspension, explaining, among other things, Frederick was disciplined because his banner appeared to advocate illegal drug use in violation of school policy. Petitioner school board also upheld the suspension. Frederick filed suit alleging the school board and Morse had violated his First Amendment rights. The district court granted petitioner summary judgment, ruling they were entitled to qualified immunity, and they had not infringed the free speech rights. The Ninth Circuit reversed, accepting that Frederick acted during a school-authorized activity, which I don't think is necessarily true, and the banner expressed a positive sentiment about marijuana use. The court nonetheless found First Amendment violation because the school punished Frederick without demonstrating his speech threatens substantial disruption. It also concluded that Morse was not entitled to qualified immunity because Frederick's right to display the banner was so clearly established. A reasonable principal in Morse's position would have understood that the actions were unconstitutional. Court is coming back in 5 minutes? Cool. That's nice. Because schools may take steps to safeguard those entrusted to their care from speech that can be reasonably regarded as encouraging illegal drug use, the school officials in this case did not violate the First Amendment by confiscating the pro-drug banner. Frederick's argument that this is not a school speech case is rejected. The event in question occurred during normal school hours and was sanctioned by Morse and is an approved social event at which district student contact rules expressly applied. Teachers and administrators were among the students and were charged with supervising them. Frederick stood among other students across the street from the school and directed his banner towards the school, making it plainly visible to most students. Under these circumstances, Frederick cannot claim he was not at school. I find that a bit dubious. But that's what the Supreme Court is going with on a 5-4. The court agrees with Morse that those who view the banner would interpret it as advocating or promoting illegal drug use in violation of school policy. At least two interpretations of the banner's words, that they constitute an imperative encouraging viewers to smoke marijuana, alternatively celebrate drug use, demonstrate the signs promote such use. The pro-drug interpretation gains further plausibility from the paucity of alternative meanings the banner might bear. A principle made consistent with the First Amendment restricts school speech as a school event in which the speech is reasonably viewed as promoting illegal drug use. In Tinker, the court declared holding school policy prohibiting the school from wearing anti-war armbands violated the First Amendment, that student expression may not be suppressed unless school officials reasonably conclude it will materially and substantially disrupt the work and discipline of the school. The court in Bethel School District, however, upheld the suspension of a student who delivered a high school assembly speech employing an elaborate, graphic, and explicit sexual metaphor. Analyzing the case under Tinker, the lower courts have found no disruption and therefore no basis for discipline. This court reversed, holding the school was within its permissible authority in imposing sanctions in response to the school's offensive, lewd, and indecent speech. Two basic principles may distill from Frazier. First, it demonstrates that constitutional rights of students in public schools are not automatically coextensive with the right of adults in other settings. Had Frazier delivered the same speech in a public forum outside the school, he would have been protected. In school, however, the First Amendment rights are circumscribed in light of the special circumstances of the school. The school's got to be able to school. So basically it's a time, place, manner restriction. The school's got to be able to school. Second, Frazier established that Tinker's mode of analysis is not absolute, since the Frazier court did not conduct a substantial disruption analysis. Subsequently, the court held that the Fourth Amendment context, while children assuredly do not shed their constitutional rights at schoolhouse gate, the nature of those rights is what's appropriate for children in school, which sounds like a time, place, manner restriction to me. Spinny fan is spinning again. Spinny fan is in fact spinning again. That is true. Spinny fan is in fact spinning again. Thank God. Spinny fan is back. As of 1 minute and 46 seconds ago. Thank Jesus. Spinny fan is back. Spinny fan is back. All is right with the world. Okay. Crisis averted. Drug abuse by the nation's youth is a serious problem. For example, Congress has declared that as part of school's job is educating students about dangers of drug use. And petitioners in many schools have adopted policies aimed at implementing the message. Student speech celebrating illegal drug use at school event in the presence of school administrators and teachers poses a particular challenge for schools officials working to protect those entrusted with care. The special characteristics of the school and government interest in stopping student drug abuse allow it. Chief Justice Roberts delivered the opinion of the report in which Scalia, Kennedy, Thomas, and Alito joined. Breyer filed a dissent in which Stevens, Souter, and Ginsburg joined in a 5-4 decision. You have audio? I don't have audio. I have no audio. Is your feed ahead of mine or something? I've got no audio. We'll tune back to Spinny Fan since the reports are that we've got audio. We'll tune back for Spinny Fan glory. You can figure out the RPM by slowing the video down. Okay, what is the RPM of the fan, please? We would like to know. You're on Boston 25? All right, here we go. All right, can we figure out what the hell is happening? Will they tell us what the fuck is going on? Probably not. Are all the jurors still there? That's even more important question. That wasn't so bad. That could have been worse. Oh no! No! Someone turned off Spinny Fan! No! 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 Turn it back on! Turn it back on!
All right, so jurors, I still have a couple of questions for you. Were you able to follow the instructions and refrain from doing any independent research or investigation into this case? And we've discussed the other two questions, but I do need to stress for you that it's very, very important that no one discuss this case, don't let anyone talk to you about the case, no comments about the case. You've seen how hard the lawyers have worked to pull this case together for you, and everybody's given it so
Joining
much
us
time. So please let's
on
make
stream
sure that we follow
is
that. That means each other. So
our friend
that
and yours, someone who will tell us exactly what is happening, I'm sure,
abbreviated breaks.
Mr.
So no morning break. We're going to
Larry Foreman.
All right, Mr. Brennan, and we're taking.
What's up, guys?
What the hell?
I apologize.
Why is my camera backwards? I don't know. I'll have to fix it.
No, wait.
Ms.
There we go.
Haley
That's
will
what I'm
be
looking
back
for.
Later for the rest of her testimony, but we've got a witness here that we'll call out of order. Thank
You're
you.
looking
Mr.
sharp,
Brennan.
sir.
Thank you, sir. So are you. I love the hoodie. Oh, there we go. Thank you.
Flipped you backwards.
So what is happening? Somebody's telling me she's polling jurors or something. Something about
Yeah,
polling.
so the court has been suspended for the last 2 hours. There was no cameras. She brought the jurors up one by one to sidebar and asked them something. And at the end of that, she just gave the admonishment she just had about it's being important not to talk about the case. So shades of the first trial.
Good morning, Doctor.
Yeah, didn't she didn't she very recently, somebody told me this, that a juror complained about something. There was rumor. Now I don't think it's rumor anymore. I think it's fact based on this conduct.
I mean, there were a couple rumors along these lines that a juror had said something about, there being too many sustains and
yes, that one.
Something like that. Yeah. So yeah.
Holy
so too many
crap.
things like that. But why don't you introduce yourself to the audience, because I think it's been quite a while since they've heard from you.
Sure. Yeah. No, man. It feels like shortly after Johnny Depp was like the last time we were on screen together. It feels like it was probably more than that. I just can't remember. But yeah, I'm attorney Larry Foreman, also known as the DUI guy. I have the show Buckle Up. It's the Law is the sign right behind me. Kurt and I have known each other since at least May of 2022. When the Johnny Depp trial was in full swing. And yeah, I do recaps. I don't stream. I streamed the first trial because I had time. Now I don't have time anymore. Work has really picked up and my associates can't keep up with everything. So I have to fill in the gaps, but it's okay. I still do. I release 2 videos a day, plus a short. So we kind of organize while everybody's watching the trial. At 1 o'clock, there's a 60-second short, 1 o'clock Eastern Daylight Time. And then at 4 o'clock, we release a long form video. Today is going to be a huge day because we're doing Burgess. And what's the second video? I did Burgess yesterday and Buchanan grilling, just absolutely grilling, or excuse me, Jackson absolutely grilling Buchanan. So those are the 2 videos today. I think Buchanan is going to be first, and then we're going to save the best for last. More Burgess. I mean, my God, this is the most. I qualify him as the #1 worst expert of the 21st century. He is absolutely everything is falling apart with that guy. So anyway, that's my rant.
Did you see the short I released about it?
I did not.
Let me see if I can pull it up on screen because it was. I was particularly proud of it. Give me a second.
I want to hear it. I want to see it.
All right, hold on. The place scary. Okay, do this. Share tab audio. Yep. Okay, bring it up on screen.
One of my moderators is in your chat. Hi, Rose.
All right, here it is in all of its attendant glory.
Your Honor, at this time, I offer Exhibit XX into evidence.
Yes.
No objection.
Are we sure it's not Exhibit XXX? Because I feel like I'm watching someone get fucked right now.
Your Honor, at this time, I offer.
That's it. It's just a very short thing. That's
That's
the
no,
entirety
you
of
have,
it.
you have to do the next part where he's just like, you lied about your credentials. No, but they're inconsistent and you didn't complete your degree in 17 bloody years.
Oh yeah.
Yeah.
No, and then I also updated my own LinkedIn I might have updated my LinkedIn. Let me know if you approve. Here's a screenshot from my LinkedIn. Let me see if I can find the
I
thing.
approve. You don't need my approval, bro. You got this.
Yeah, this is my new entry on my LinkedIn.
President current. Okay, that's funny. That is really funny. I more than just approve. I think it's hysterical.
I'm here for it.
That's really good, Kurt. That is really good.
All right, whenever you're ready, Mr. Brennan.
Thank you, Your Honor. Good morning, sir.
Good morning.
Here
Could
comes the
you
yelling.
please introduce yourself to the jury, spell your first name and last name for the court reporter?
Sure. My first name is
Also, on just like on a strategic level, why, if you're Brennan, on God's earth, do you call Shannon to the stand? I mean, you obviously don't have to. He's a paid expert. You can just not. Why do you call him with those kind of liabilities? What the hell were you thinking?
He wasn't. Number one, he has too many witnesses. Number two, he can't keep track of them. Number three, and at the end of the day, it's all a show. They don't care if they win because they know they're not going to win. They just have.
But it wasn't. But it's not a good show either. He's a disaster fuel.
I agree. Go ask Brennan. What is your strategy here, bro? I don't know. I don't think he has one.
Yeah. Okay.
Yeah.
Isaac, Aizik. It's phonetic. Last name is Wolf, WOLF, like the real thing.
What do you do for a living?
I'm a brain surgeon.
Is there a special part of medicine that you study?
Well, my main interest in brain surgery is brain tumors and trigeminal neuralgia. But I also specialize in movement disorders. I do pediatrics and adults.
Are you an active working neurosurgeon?
I am very active working neurosurgeon. I get up every day at 4:30 in the morning to go to work, 5 days a week. I take call 300 days out of 365 days a year.
Did you work yesterday?
Yes, I did.
What type of work did you do yesterday?
I did 2 brain surgeries yesterday.
Are you working tomorrow?
I have 4 surgeries scheduled for tomorrow, which is why this is a little bit delayed
can you
for
do a
me,
brain
and
surgery
I have
right
4
now?
on Friday.
And what
As
type
we
of
speak?
surgeries do you have tomorrow and Friday?
I have 3 brain tumors, 1 trigeminal neuralgia, and on Friday I have 4 patients with movement disorders.
You're here today as a witness. How much of your practice, how much percent of your income is from being a consultant or a witness for a case?
Probably less than 1%. I don't do this for a living.
I want you to take us through some of your education and background. Could you share with us where you went to medical
Which
school?
degrees
where
are you currently
graduated from?
pursuing, Dr.
I went to
Wolf?
Yale Medical School. I graduated summa cum laude.
Was that in 1981 that you graduated?
Correct.
After medical school, did you begin internships in medical
Not to be
residency?
confused with
I did an
1986.
internship at Hennepin County Medical Center, which is a trauma center in Minneapolis. I then did 5 years of neurosurgical residency at the University of Minnesota.
And was that in Minnesota?
Correct, in Minneapolis.
Is there something about that hospital that has some specialty?
It was one of the number 1 training centers for chairmen in neurosurgery at the time.
Did you, in your residency and in your fellowships, do any work or study in pathology?
During your residency as a neurosurgical resident, you do 6 months in neurology, you do 3 months of neuroradiology, you do 3 months in pathology, which includes autopsies on brains, and then you do rotations through a trauma center as a chief resident, through a VA hospital, and then ultimately at the university hospital for elective cases. We also do 6 months of pediatric neurosurgical residency.
Did you do a fellowship at New York University?
Yeah, at NYU, I did a fellowship before I went to the University of Maryland as a professor in brain transplantation. The interest was in using cells to create dopamine centers in rat brains with the concept of Parkinson's being curable with transplantation.
I'd like you to take us through some of your faculty positions, and so you can share with us some of the progression of your training and experience. And did you begin at the University of Maryland Hospital?
Yes. In 1987, the University of Maryland recruited me to start their epilepsy surgical program and skull-based program. And then part of our responsibilities as assistant professors was to cover shock trauma.
Could you explain for us what shock trauma means and whether the University of Maryland Hospital was a shock trauma hospital?
So the University of Maryland and shock trauma were actually two separate entities when I started. A man named Cowley had basically developed the concept of the golden hour. So prior to Dr. Cowley, most trauma was just taken locally. That meant as a community hospital, if a patient had been in a motor vehicle accident, they needed an orthopedic surgeon, they had to call the orthopedic surgeon in, could take 15 minutes, could take 3 hours. The same thing for a vascular surgeon, the same thing for a neurosurgeon. Dr. Cowley came up with the concept that you needed a center that was strictly for trauma, and every attending had to be in the hospital 24/7. So that was the concept of shock trauma back in the 80s. When I got there, we were transitioning from a very small center to a 125-bed hospital that was completely committed to trauma.
In that experience, in the years you worked there, did you have an opportunity to treat a number of people with brain injuries?
We treated well over 100 patients a year, a month basically, with brain injuries at shock trauma, along with spinal cord injuries.
Did you perform surgeries in different types of brain trauma and brain injuries?
Yes.
After Maryland in 1993, did you move to Miami Neuroscience Center?
Yes. In 1993, I left academics. I went into private practice in Miami, and I started the Miami Neuroscience Center. We were the first private community hospital to have what's called the Gamma Knife. So we were the 13th in the country, but the only one that was non-university based. And Gamma Knife radiosurgery is using radiation to operate on the brain.
Are you presently the director of the Miami Neuroscience Center at Larkin Hospital?
Yes, I am.
Do you conduct a number of surgeries a year there?
Correct. So I spent 19 years at Doctors Hospital, then we moved to Larkin Hospital 13 years ago, developing the new radiosurgical unit called ZAP, and also another fancy machine called high-frequency ultrasound to treat the movement disorders.
You've noted that you have a number of professional memberships. I don't want to go through all of them. I'd like to point out a few. Are you a professional member of the American Association of Neurological Surgeons?
Yes.
Are you a member, a fellow American of the College of Surgeons?
Yes.
Are you a member of North American Skull-Based Society?
Yes.
And is that brain-related?
What kind
It
of
is.
name is that?
Is that
Are you a
where
member of
George
the
Bush and
Society for
Obama belong to, the Skull and
Neuro-Oncology?
Bones Society?
Yes.
Something
Are
like
you a
that,
member
yeah.
of over, or at least 34 different professional memberships?
Yes.
34, huh? How do you keep all those
In
active?
your career, have you engaged in research?
Yes.
Has that research focused or centered on brain injury?
Yes, it has.
Is some of your research as a
guess,
principal
he's about to
investigator
say there's
for
100% chance he got hit by a
THAM
car.
treatment of brain tissue, acidosis, and severely
0% chance he was
head-injured
beat up.
patients?
Yes.
Did that research and as a principal investigator help you in your diagnosis and treatment of brain injury?
I mean, he's no
It
rocket
actually was
scientist,
in the
Larry.
treatment of severe head injuries, patients who were unconscious, the concept of trying to relieve the increased intracranial pressure that occurs from the injury and to increase blood flow, thereby increasing oxygen to the brain.
Did you also serve as principal investigator for research for the PEG, SOD, and severe head injury?
Yes.
Could you describe that very briefly?
Basically the same, one of the biggest problems in brain injury is the fact that blood flow ceases to exist as the brain swells up. And so one of the things we try to do is preserve the neurons by making sure that they have enough oxygen and blood flow to them. All these are agents that try to assist that.
I won't go through all of your research and principal investigator roles, but I want to ask you about one more. And that is, did you serve as principal investigator relative to the IRB protocol for brain pathology?
Yes.
And what did that do? What was that about?
It was about looking at what happens after a brain injury to blood vessels and tissue as the intracranial pressure increases in the brain.
Have you been part of publications of a number of different books?
Yes.
I won't list parts of all 16 books, but can I point out a few?
Sure.
Were you the author of a book chapter regarding head injury, difficult medical management?
Yes.
Were you the author of a book chapter on pediatric neurosurgical emergencies?
Yes.
Were you the author of a book chapter on complications of head injuries in adults?
Yes.
Were you an author of a book chapter, Imaging of Craniocerebral Trauma?
Yes.
Were you an author of a book chapter in Emergency Room Assessment of the Head Injury Patient?
Yes.
Were you the author of a book chapter, Intracranial Injuries?
Yes.
I thought I was going to have an intracranial brain
I won't
bleed
list or
yesterday,
ask
so
you
maybe I
about
should
the
be
other
talking
book
to this
chapters that
guy.
you've been the author of. Have
I'm
you
getting a brain bleed
been
just
involved
listening to
in
him.
journal articles?
Yes.
I'd like to ask you just about a few of the 70 journal articles that you have published.
Your Honor, objection.
So go ahead and ask the question without a comment first.
Were you an author of a journal article, Intracranial Pressure in Non-Traumatic Ischemia and Hypoxic Cerebral Insults?
Yes.
Oh my
I
god.
understood some of those
Were you
words.
the author
Yeah, I
of
was
a
about to
journal
say
article,
two key words.
Post-Traumatic Cerebral Infarction?
Yes.
Were you the author of the journal Fractures of the Clivus?
Yes.
Could you tell me a little bit about that paper?
We used thin-cut CT scans to identify fractures of the skull base. Prior to this, prior to CT scans, it was very difficult to actually identify radiologically a skull fracture with plain X-rays. The idea was to see if we could identify them more clearly, and so we classified them and delineated them in the paper and discussed the outcomes that were relative to those type of injuries.
In the last journal article I'll ask you about, were you the author of a journal article regarding acute traumatic midbrain hemorrhage?
Yes.
Were you the presenter in a number of presentations regarding head injury and brain injury?
Yes.
You've listed 93. I'll ask you just about a few. Were you a presenter in fractures of the clivus, clinical and radiographic features?
Yes.
Am I
The
pronouncing that
clitoris?
correctly?
Clivus.
Thank you.
Oh, Clivus. Sorry.
Were you the presenter
brain went
in
in the gutter.
acute head injury?
Yes.
And a separate presentation, fractures of the clivus, classifications and clinical features?
What's a clivus?
I think it's
Yes.
pronounced clivus, but I
Do
could
you
be wrong.
lecture?
Yes.
Or at least that's how I always pronounced it.
What is it?
It's a part of the brain. It's
Do you have peer-reviewed publications?
I forget. It's like really
Yes.
at the stem,
That
I
was
think.
one of them.
It's
Oh,
in that
okay.
general area. Rose is a nurse. She might be able
And
to tell us.
are you heavily involved in
Okay.
clinical
Do
research?
I have one of those, Rose?
Right now, my research is more based on radiosurgical
You asked about
techniques.
clitoris
and
or
outcomes.
clivus?
Over your career and your study and your clinical experience, have you treated different types of brain injuries?
Yes.
Are you familiar with a number of different
Unless he'll
types
be
of
doing
brain
the cross
injuries?
probably because he's
Yes, we still treat them.
Were
he a
you asked
pharmacist?
to review materials relative to this case?
Alessi?
Yes.
Yeah.
And do you recall the materials that you
I wouldn't
reviewed?
be surprised.
Yes.
Could you share with us some of the materials that you
I-
reviewed?
I
Two guys
reviewed the
asking
chief
where
medical
the clivus
examiner's
is.
assessment of the case.
Yeah. How do
I reviewed
how do I
pictures
find it?
that
How
many
the
guys does it
chief
take-
medical examiner
how many
took
guys does it take to
of the
find a clivus?
autopsy. And I
Reminds me of the South Park
reviewed
movie.
the report from the forensic pathologist.
And before I ask you about your review of specific
I hear it's a
materials
myth.
and your opinions in this case, is there a benefit to your clinical experience in studying brain injuries as opposed to the experience you had as a fellow simply with pathology?
Well, I think that for the jury to understand is a clinician understands the process from the time the injury occurs till the patient either
Yeah, and
leaves
he
the
has
hospital
4 surgeries
or
scheduled for
dies.
tomorrow.
Yeah.
And it's a process.
I was under the
And as a
impression brain surgery
neurosurgeon,
was a little bit more
I
complex
have
than that.
a
But I guess we
tremendous
can
amount
pump
of
him out,
experience
man.
with that, if that's what you're asking me.
Yes.
Yeah.
And so, doctor, you reviewed a number of items of information in this case.
Your brain
Did you
surgery in
have
30 minutes, or your
an
next one's
opportunity
free.
to review photographs of a laceration
be a lot
to
for one
Mr. John
person.
O'Keefe's head?
Yes, I did.
With the court's permission, I'm
Can you
going
pause it
to
for a
ask
second,
to
Kurt?
display exhibit.
I'm so sorry. I know your chat is very excited about this absolutely stellar testimony that I'm sure they can't look away from. But I'm sorry I can't stay much longer. I have to dip out. Chandler needs me.
Aw.
I know. I'm a very busy guy these days. I don't stream anymore for this reason. But I will try and join you maybe tomorrow or maybe next week.
Yeah, we'll still be here.
Yeah, I mean the trial. How long do you predict the trial is going to go, Kurt?
They were saying 6 to 8 weeks. That sounds roughly correct. I think the Commonwealth
From
is getting ready
today?
to rest pretty. They're going to rate. I think they're getting towards the end. So the rumor was they were going to rest this week, and they certainly seem like pacing is for that.
Wait,
The
what about Matthew McCabe, Brian Albert?
They're not calling any of those people.
What?
No, I mean, yeah, they're not calling Proctor, but any of the McCabe's. They're not calling any of those people.
Well, the defense circuit is going to call all of them.
Yeah.
Oh, so that's why it's going to be 6 to 8 weeks. Oh, wait a second. This changes the calculus entirely.
Yeah, no, I know. I had to redo the calculus as well based on that factor. Not calling Proctor feels like a strategic error.
They can lose now. I didn't think a not guilty was going to be possible. Brennan is going to secure the not guilty for Karen if he does not call Proctor or Brian Albert. I mean, the owner of the house, the lead investigator. Oh my, Brennan. I think Brennan is under instructions to what is it called? To basically lose this trial. There's a word I'm looking for. I just can't find it right now. Chat.
Throw it.
Throw the trial. Thank you. Brennan is under instructions to throw the trial.
You think so?
100%. There's no way. Why else would he not call like 90% of the witnesses that were called in trial number 1?
Yeah, I mean, especially with Proctor, it feels like a strategic error because the conventional wisdom would be you draw the sting. I mean, he's a walking disaster area, especially with being dishonorably discharged. But the conventional wisdom from trial advocacy would be like you call him as the prosecutor.
Yeah.
You ask all the questions the defense is going to ask, but you ask them more softly. You ask them with more gingerly.
Yep.
You don't really give the defense anywhere to go because you've
No.
already asked everything.
Exactly.
You build a little credibility.
Yep.
If it was in, he's going to try to rehabilitate him on cross because his redirects are so good that he can build this all back on cross. What the fuck? It seems like a strategic error. And as the defense, how do you not call Proctor? I could see them not calling any of the other people, but isn't there like a 95% chance the defense calls Proctor? Because what's the downside?
100%.
Any answer he gives me is good. He
Unless-
confesses to it all, it's good. He
unless-
fights me, it's good. Every answer is good.
Unless Proctor is in Bermuda, then good luck procuring him.
Well, then I'll just read his testimony from the last trial into the record. Witness unavailable. Prior sworn statement. Both parties were there. Same matter.
True.
As the
gonna read
defense,
it?
as the defense that's introducing it, so you don't even have Sixth Amendment issues.
Who's going to read it?
I don't know. I'm available. I'll play Proctor. It's the role I was born to play, Larry.
There's 100% chance they call Proctor. I would 95 is too low. I'm with you, Kurt. There's a 110% chance they call Proctor if he's around. And oh my God, you're saying that the prosecution is going to rest by Friday, the 23rd of May?
Yeah, and everything about the pacing
What?
everything about their pacing of the witnesses
What?
confirms that to me. Because I mean, this is this is what
Where did you get this information? Sorry.
I mean, this is what has been. Court TV was actually reporting this as true like a couple days ago. Court TV felt confident enough about it, they were reporting it that the
Okay, yeah.
prosecutor
Well,
wasn't going to call these
Court
people.
TV are not confident enough to have DUI guy on their channel. I have official confirmation now because they invited me for. They emailed me last week. It was like Brittany Dunk, I think her name is, that works for Court TV. She emailed me and she was like, "Hey, Larry, we'd like to have you on your show on Tuesday, May 20th at 8 p.m. I was like, "Sure." And we went back and forth. We have like 17 emails back and forth. And each one is just like, "Hey, can we have what's your title? What are your talking points? That's awesome. Okay, we're going to submit this. We're going to submit that. We may have some questions for you." I'm like, "That's no problem. Here are the questions. Here are the answers." Okay. Hey, actually, the show is not going to be at 8. It's going to be at 9. Is that okay? Yeah, absolutely. Okay, cool. See you tomorrow. See you tomorrow. See you tomorrow. See you tomorrow. Morning of. We'll get back to you. Mulligan.
Aw. Why not, man? You're a great guy.
I think I don't know. I'm honestly the show didn't happen, as far as I could tell. When I say the show didn't happen, I mean I couldn't find it on their channel. I don't know if it's on a paywall. If it's a sister channel, I don't know. I don't care. Maybe they're moving it to a different day, which is fine if they are. I mean, I'd like some notification ahead of time. But I don't know. Some people said that like Colin's lawyer may have objected, or Julie Grand, who has blocked me because I called her shit out, and it's great. I love it. I mean, people. The funniest thing, Kurt, is that like I can see myself within like a year and a half being a bigger channel than Court TV, like subscriber wise, because I produce more content than they do. It's just gonna take some time. I'm not in a hurry, but like they are crawling.
Yeah, what are you at these days? 600 something?
I'm almost at 600. Yeah. But
yeah, you're doing
like,
great.
Law and Crime, if you remember during the Johnny Depp days, Law and Crime was at like 2 million. Court TV was like 1.1 million. Law and Crime is at 7.5 million right now, I think. And Court TV is barely, not even approaching 2 million. Like, I don't know. It's because their content is just not as good. They're like the TMZ of LawTube. You know what I mean?
Well, I think probably it's one of the major issues is it's corporate, so it's safer, and by being safer, it presents its own problems because people are able to take edges that are more interesting in some ways, and they're not willing necessarily to take risks because it's they're afraid of risks are risky.
Can I just vent for like 15 seconds since I have an audience?
Take your time.
I don't really do lives, and then I'll dip out. I promise I'll give you your show back. So look at all the main players right now. Like Law and Crime, Court TV, we talked about. Oh shoot, I'm on the full screen. That's not good. This is gonna get clipped. Like look at all the main players we have right now. We have Melanie Little and Andrea Burkhart, who are doing a phenomenal job commentating. We have Peter Tragos, who I am waiting for him to get off the fence. We have Emily D. Baker. I don't know. I don't watch her. I don't know what she's up to these days, but she seems to be following the trial closely. Alita, she dabbled into the trial and she realized she makes more money getting more views in doing like CoffeeZilla and Logan Paul and all that, because she did like 5 days of trial, but her views were like really, really low. So she went on doing other things. Who else do we have? We have you, Kurt. Kurt, you're doing a phenomenal job commentating on this trial. You have a legal mind, legal analysis. Your audience is educated, So like me, I'm not even doing live commentary. I'm doing like recaps, which is a different genre, but I'm still covering the trial. And like Nick Stero, I just recently, I didn't even ask him. I was like, Stero's not covering this trial. I'm like, why? And he's like, well, everyone's doing it, so I'm going to do something else. I think that's a loss for Stero. I think he should be covering this. And anyway, like honestly, I think everyone is falling into their own category, and it's just so amazing to see how far we've come, Kurt. You, me, and everybody else I just mentioned. Oh, and Nick Rekieta. How could I forget? Rekieta is now covering. Rekieta's back. Rittenhouse OG is back. He's covering the Karen Reed trial. So I'm just really excited to see that everybody has like an audience. Everybody has like a plan. Everybody has like Emily D. Baker. She has 2 sister channels now. She has her main channel and like the Emily Show channel. So she does like recaps on one. And I watch her. I
mean, Emily's killing it. I think she's getting 35,000, 40,000 watching.
I think it's more than that. But Andrea Burkhart is stealing a lot of her audience now because, no offense to Emily, or maybe all offense intended, I don't know, take it how you will. but Andrea is better, so much better. I don't think
Andrea
that,
has long been the person I say is the most underrated. She is so wicked
I will
smart.
say this first. I am number 2. She is number 1. I've listened to her. I like the way that she analyzes. I like the way that she thinks. I will take the number 2 or 3 spot. And my camera just went out.
I noticed.
But anyway, and Runkle, is Rob doing this? I'm forgetting people. I don't know.
That's all right. You don't have to mention everyone. It's not attendance.
Line
It's fine.
Lumber. No, I know. It's just like I'm so excited for everybody. It's nice. It's really nice.
Yeah. Well, thank you for dropping by, and we hope to see you again tomorrow.
Definitely, man. Thanks for the invite.
All right. Bye-bye for now. Yeah. That was our good friend, DUI Guy Plus, I believe is his channel name. It's tagged in the title. Make sure to check him out as well. And yeah, I mean, it's this is one of the things I'm going to be talking about later today with Vinny. We're going to be talking about the status of media generally relating to courts and true crime. I think that's what I want to really spend the bulk of my time talking with him about. What is his perceptions of the state of the media and the state of the interest, and what is the state of these things? Because I think he would have some interesting insights from his own perspective, of course, working for a corporate player, and also what the independents are doing and what we can learn from each other. You know, what can the independents learn from corporate? What can corporate learn from the independents, and so forth and so on? And that's one of the things I really want to spend a lot of time talking with Vinny later today about. So I'm really looking forward to that discussion. But I share, you guys know that, like, I was dumbfounded by the state not calling Proctor. Larry shares my dumbfoundedness. Larry agrees with me that this is an unforced error. Larry thinks it's even a bigger unforced error than I gave it credit for, which, fair enough. He thinks he thought, that this is enough to basically throw the case. And like, okay, I mean, I don't know if I necessarily go that far, but it is an unforced error. Like, what is the magnitude of that error is, still a bit in the weeds, but it's like, yeah, we both agree with that. So, and I certainly echo his thoughts relating to the media that is covering this as general, with respect to Emily and respect to Melanie and respect to Andrea, who I have said and will continue to say, I think Andrea is the most underrated. She is, Larry says that she's smarter than him, and I think I think she's smarter than me. She's the person I'd most want to work with or most want to work against, because either way, she'd make me work for it. Right. If I work with her, obviously, she's a genius and it would be great. If I work against her, if we're on opposite sides of the V, she's going to make me work for it because she's so wicked smart. Andrea Burkhart has long been my person for the most underrated in LawTube. And she is so incredibly smart, and she does her homework. She really does her homework. She's so well informed about things, and she's just, I admire her so much. And, yeah. So all those things. So yeah. Anyways, let's resume back with the trial. And the digital pics behind me look great. Thank you. They are looking pretty decent. Let's resume with the trial. Where were we?
It's 160.
Okay.
Dr. Wolf, I'm going to ask you to take a look at this photograph. Have you seen this photograph before?
Yes.
I want you to explain to us what you're seeing here and take us through the process of your observations.
Well, what we're seeing is an approximate 1.5 inch laceration.
Plus, I like Andrea because she is literally an appellate lawyer. And so I think one of the reasons I like her in particular is because her mode of thinking is the most similar to mine. Who was it who said that genius is the way that we think, just more so? That the definition of genius is just what we are, but more of that. That's what genius is. So one of the reasons I respect Andrea is because her mode of thinking is the most similar to mine, because she's an appellate lawyer. She's a criminal appellate lawyer, but she's an appellate lawyer. So her way of thinking and legal reasoning is the most akin to mine. And she's really fucking good at it. So, yeah.
With bridging tissue and contusions and abrasions. To us, that's just a class.
Oh, by the way, in terms of the jury, there was a note. Sorry. According to Turtle Boy, one of the jurors has reportedly moved seats. The juror in the seat closest to the witness box, Turtle Boy writes, saying, I, Turtle Boy, frequently observed him joking around with the woman next to him during sidebars. So apparently that was some of the issue. So for whatever it's worth, noted. Continuing with the trial.
Classic blunt trauma injury. There's nothing other than just vanilla about it. This is what happens when soft tissue hits a solid ground. The skin tears apart a bit, but not through and through. As you can see, there's the bridging. You can see all the bruising or contusions and just the tear, a little bit serrated along the edges.
Thank you. If you could take that down. Dr. Wolf, as a result of that wound, did you have a chance to further look at information provided to you about the actual inside the skull of Mr. John O'Keefe?
Yes, it was the pictures that I was reviewing showed a non-depressed skull fracture extending linearly through the clivus and into the frontal fossa of Mr. O'Keefe over the orbital roofs. He had fractures along the temporal fossa as well. So it was a classic linear basilar skull fracture.
Is basal skull fracture a
It's
characterization?
basically the base of your skull is what it encompasses. So the opening at the very bottom is what we call the foramen magnum. That connects your brainstem to your spinal cord. And then as your brainstem goes up, it goes into the different skull areas that, talk about what we call the cerebral cortexes, your occipital lobe, your temporal lobes over here, and then your frontal lobes.
So can you walk us through what happens when someone incurs this type of injury to the back of the head, how it happens, and what are the next steps for a person?
So what happens is, you fall backwards, and the linear acceleration starts to take you back down with gravity. The skull hits the ground. It gets, in layman's terms, smashed a little bit. And then the brain moves forward as a response to that. And it moves forward because you have cerebral spinal fluid and because you have the deceleration, acceleration again. As it does, your skull, if you were to look inside your skull, it's like mini mountains along your temporal bones and your frontal bones. So the brain is being thrust forward at a fairly good speed, and it's getting bruised. You can think of it as if you took a hammer to your thumb. It's really turning black and blue. Those are the contusions. And so the temporal poles and the frontal poles are getting contusions because of that. At the same time, you have a space called the subarachnoid space. And I'm sure they're going to hear about the subarachnoid hemorrhage. And
Something spider?
that space is it's very clear, thin membrane that covers all of your brain and all of your spinal cord. And normally, you really don't see it unless you open up the brain and you're operating. But when you either have a traumatic event like this, where little vessels are pulling apart underneath that membrane, or, for example, the classic, when you have an aneurysm burst, the space that the aneurysm bleeds to is the subarachnoid space. The other thing that occurs in trauma like this is you can get a subdural. So The dura is the membrane that covers the whole brain and also right down your spinal canal. And it's a very thin membrane that looks like very thin leather. And in that space between the brain and the dura can be a lot of veins that go towards a central vein called the sagittal sinus. And if those tear, you have a venous hemorrhage from, which is not arterial, so it's not quick, but that can develop into a subdural as well. If you tear a portion of your brain as well, and you get a little arterial bleeds, that could create a much faster subdural hematoma. And so when you look at the pathology, the autopsy of his brain, you're looking at a subarachnoid hemorrhage, you're looking at a subdural hemorrhage, neither one of them which was huge or would have required surgery, as well as the contusions that I described in his frontal poles, in his temporal poles, and then the original bang, which was in the occipital area. These are all findings that you would see on a CT scan and an MRI scan without requiring an autopsy if he had made it to the emergency room.
I want to take a step back. At the beginning, you said that this laceration on the back of his head was caused by a fall. Could this be caused by a fall landing on hard ground?
Yes, I mean, like I said, it's a classic blunt trauma laceration.
Do you have an opinion to a reasonable degree of medical certainty whether this injury, the laceration and the basal fracture, was caused by Mr. O'Keefe falling backwards on the ground?
My opinion is that that's what caused his whole injury.
The pattern of the laceration, do you have an opinion whether that is consistent with hitting the cold, hard ground?
Objection, Your Honor. Could we have sidebar on that, please?
So I'm sustaining the objection, so no sidebar.
Your Honor.
Do you have an opinion, doctor, about whether that laceration on the back of his head was caused by a particular movement?
Well, the only way he could get this kind of an injury was to fall backwards, hit the back of his head, and then the resulting, energy forces going into his brain, into his base of his skull.
Would that type of laceration require Mr. O'Keefe to have hit a line type or ridge type object?
A ridge type of object?
Yes.
No, I mean, like I said, the tearing of the skin in that fashion, you could look it up, would be just a classic blunt trauma injury.
Is there anything about that injury that would suggest to you it had to have been something sharp or ridge-like to cause?
Objection, Your Honor. Again, request kindly a sidebar on this.
All right, we'll come to that.
Thank you.
This guy is certainly very, very credible. If whatever else you can say for him, he's incredibly
Breaks.
credible.
Not necessarily.
And have you seen, in your experience, similar types of lacerations and breaks caused by falling on hard ground?
If this is like the state's last witness, if this is like their, if this is their, mic drop moment with trying to prove that, this injury was caused by this, if this is their witnesses that is going to prove that the car hit him and all the rest of it, if they can get what they want out of this witness, if this is their mic drop witness, it's a pretty good way of capping the state's testimony. So I will give them that point, because there's no court on Friday, right? So we're looking to end this by the end of the day tomorrow. So if this guy is their last witness, and it's looking like we are, and this witness really pays off for them, this could be, their moment of triumph or their way of really. So this could be really positive for the state. So I think we really need to pay attention and see how it's playing.
Yes, you can see that both in the occipital region. You can see it if patients fall on the, forehead. The skin tears.
He's not getting the answers he wants yet, but I mean, he's laying foundation, and he's getting partly the answers he wants, but he hasn't really asked the questions yet to get the answers he wants. But he's gained partly the answers he wants. So so far I think it's gone good. We'll see.
They're still bridging, and then they get bruises.
Some of your work was in Minnesota.
Correct.
Was it a colder part of Minnesota?
Very cold part of Minnesota.
Did you-
It's Minneapolis.
I'm sorry. Did you often see these type of injuries there?
Yes, I mean, we took care of a trauma center, Hennepin County. Very frequently, patients that are drunk fall down on ice sidewalks and could develop, lacerations in their head, epidurals, which are blood clots above the dura because they fracture a bone in the temporal area and they can get a bleed from a fractured artery. And it happens when people are shoveling snow and have a heart attack and fall backwards. So there are various ways that people fall, resulting in head injuries and lacerations to their forehead or to different areas of their head.
Can somebody suffer this type of injury simply by falling backwards?
Absolutely.
You had taken us through the process of falling backwards and then talked about what happens to the brain. Can I ask you a couple detailed questions about that?
Sure.
When you explained that the brain upon impact then shifts forward and hits the front of the skull, is there a medical term for that process?
Well, the medical term is a coup counter coup injury.
I've heard that before.
So the coup is when you first hit. In this case, it was the back of the head, as summarized by the laceration in the back of the head, and the contusions that the pathologist and the ME found in the back of the brain. And then the brain shifts forward, and as it's traveling at a certain velocity, because it's thrust forward on the floor of the base of the skull, it's getting bumped, and it's getting, again, you can think of it as a hammer hitting a thumb. It's getting black and blue in the areas that are sharpest.
Are there symptoms that result of the process coup counter coup?
This is clinically, it varies. I mean, you can go from anywhere from a simple concussion, where you sort of are unaware of what happened, but you're still awake, you're confused, all the way to, ultimately being in a coma.
Can this type of injury, the coup counter coup, and what you see in the review of your files, could this type of injury happen from an attack by a weapon, like a bat or a hammer?
Well, he did not have a depressed skull fracture. So any focal hit like that would more likely than not have caused a depressed skull fracture. Blunt trauma, the way he had, the assumption, would cause the coup counter coup without a depressed skull fracture.
When the coup counter coup process happens with the skull fracture, does anything happen to the front of the skull?
Well, you're asking me, does the rest, I mean, the forces, depending on how hard they are, can generate fracture lines all the way to the anterior fossa. So you can have fractures along the lateral temporal area. You can have fractures along the orbital roof. The orbital roof is very thin. And so those forces can go all the way to that area.
Did you see any sign of orbital fractures in Mr. O'Keefe?
Yes, he had both the ME and the pictures taken, and the neuropathologist mentioned fractures of the orbital roof.
Do you have an opinion to a reasonable degree of medical certainty how those fractures occurred?
From the trauma.
Could you just explain a little bit how that would happen?
Well, as he fell backwards and he struck his head, it was clearly at a very high speed generated by the gravity. The bone, depending on the quality of his bone, the density, then generated forces. There's a certain amount of lateral give, and then you get a linear force going forward. It drives all the way up the clivus, and forward into the anterior fossa where his orbital roofs lay. And this is why people like this get what they call raccoon's eyes.
Do you have an opinion whether the brain itself could have caused the orbital fractures?
No. The brain is a soft substance. You could literally put your finger through the brain. We often operate on people fully awake. The brain couldn't possibly cause a fracture. The fracture was caused by the forces generated through that clivus, that middle bone in the middle of his base of the skull.
Do you have an opinion to a reasonable degree of medical certainty whether or not the brain in any way could have caused these orbital fractures?
The answer is absolutely not.
In your study of the records and photographs, and in your experience treating these types of injuries, do you have an opinion to a reasonable degree of medical certainty whether or not a person would remain conscious or would be immediately unconscious after the impact of the ground?
Well, it's impossible to know whether he became immediately unconscious, but his injuries were very substantial, and it's more probable than not that at some point he quickly became unconscious and was unable to do functional activities.
What does functional activities mean?
The ability to, get himself up and about would be one of the functional activities. The ability to call for help would be a very significant cortical function. And that's why I was talking about, that there's a variation on the theme from a simple concussion to a severe concussion like this.
If a person does not have functional abilities because they are rendered unconscious, does their body, could it still move?
Yes, this is the interesting thing about our brain. So the cortex, which is the top portion of your brain, can get separated from your brainstem functionally. And what happens then is that your body is not acting autonomically, meaning vegetative. So why does that happen? We think it's because as we were a caveman, and if a caveman became unconscious, as an animal came up to eat it, the animal would touch it. Well, you have these automatic movements. One of them is called decorticating, which is where you draw your arms like this and you throw your feet out. And then a worse neurological situation is when you decerebrate. Now you push your arms out along with your legs. And that would scare off an animal. So we think that over time, genetically, this is what happened to our brains in order to create these. But those kind of movements are not thought processes. In other words, your brain is not telling you, oh, you have pain, go ahead and decorticate or decerebrate. It's an automatic movement in response to pain.
I want you to take us back now to after the fall. Would Mr. O'Keefe, in your study and opinion, have died immediately?
No.
Can you share?
I don't.
I'm sorry.
Yes, I'll tell you. There is very few things that you head injury where you would die, quote, immediately. So if I took a knife and stabbed you in the back of your neck right below your skull and I drove it through your brainstem, you would probably die immediately.
Nice.
If I shot you
You okay?
below your ear and went through and through below your ear and shot through your brainstem, you would die immediately. But traumatic head injuries, you would not die immediately. It's a process. And it's a process of a combination of things. Brain swelling, which takes a while to develop. Decreased blood flow to your brain because you're getting swelling. And ultimately, death of the brainstem that controls your heart, and you're breathing. And so this is why there is a whole big issue about brain death. You know, when is someone brain dead? Because it's not instant and it can take a long time to be conceived. In these injuries that are very severe that we took care of, there was a high mortality rate. In the linear skull fractures, it was about 67%. But it took time for them to die. It could take days to weeks to months. And also, these people got to shock trauma, so it was a while, whether it was hours, before they were even starting to be taken care of, and yet they weren't dead yet. That's why I don't think it was immediate.
Was there any other observations you made about Mr. O'Keefe or his body that support your opinion that he didn't die immediately?
Well, the medical examiner took pictures of his periorbital area and diagnosed raccoon's eyes. So raccoon's eyes occur because there's leakage through the orbital fractures into the periorbital space. Normally, it takes about 24 to 48 hours to develop. It has been noted as early as 1 to 3 hours, which would make it not immediate.
Could we please have Exhibit 14? Dr. Wolf, could you share with us what you see here in this picture?
So right here, you can see the black and blue that sort of configures, if he had his eyes open, like what we describe as raccoon's eyes, right? And that's not caused by direct trauma to his eyelids. It's caused by what I described as the basilar skull fracture, which went to the anterior fossa, which is right over the orbit here, inside with leakage of blood products into that periorbital area.
You mentioned that starts or takes at least 1 to 3 hours to begin.
Minimally, yes.
You take that down, please. If Mr. O'Keefe had been brought to a trauma center or emergency room, what would the process be in your experience?
Well, he would have been intubated if he wasn't intubated in the field. One of the first things you need to do in a head injury is control the airway. Why? 2 reasons. One, you want to have enough oxygen going to the brain to feed it. And 2, you want to keep your carbon dioxide down because that causes increased intracranial pressure if it elevates. So you want to constrict the blood vessels a little bit. Then he would have had a CT scan immediately in order to assess whether he has a surgical head injury, meaning he needs to go to the operating room to evacuate something, or not. During that process, he's obviously going to be getting medication to decrease the brain swelling. And from there, you make decisions based on his neurological function and what you're, capable of doing to, spare the brain from the rest of the injuries that will result. One of the things that occurs with contusions is, a great medical term is they can blossom, which means they can get bigger. And if they get bigger, they might require surgical intervention to decrease the pressure as well as the volume of the blood that's destroying brain. And so you do serial CT scans in these patients over time, anywhere from every 6 to 12 hours to on a daily basis, depending on what the case-by-case, production of blossoming is occurring.
You mentioned that about 2/3 of your patients who suffer this injury pass.
Correct. What we saw is that in the patients that suffered linear clavicle fractures, 2/3 of them ultimately went on to die, and 1/3 lived.
Is there commonality on how they pass?
One of the common reasons they passed is if they trapped a major vessel in one of the fractures, they would get a significant brainstem infarct, meaning a stroke, meaning lack of blood flow to a very significant portion of their brainstem. And so that was one of the causes of death that ultimately we understood. And then the others died from the increased intracranial pressure that drove the brainstem down through the foramen magnum.
Did you review any materials that talked about or identified Mr. O'Keefe's body temperature when he was treated?
As I recall, his core temperature was 80 when he was found.
Is that significant in the process and development of his injury from the moment he fell and hit his head until his ultimate passing?
Well, hypothermia, if you define hypothermia, it starts at 95 degrees. Your core temperature is usually about 98, 98.6. 95 is very mild hypothermia. When you get to 82 degrees, you're in severe hypothermia. What happens when you're hypothermic, and I'm a neurosurgeon, but I can tell you that you get into multiple organ failure. Your heart starts to have problems. It can have arrhythmias. You're not breathing. And ultimately, at hypothermia, you also become unconscious and go into a coma-like state. Below 80 degrees, you're probably going to die. So all I can tell you, it wasn't helpful that he had a significant head injury and that he was then found hypothermic.
Is it uncommon, in your experience, for people that suffer this injury to pass within 5 hours?
Well, none of the patients we treated died within 5 hours, but it also didn't mean that we didn't realize that they were going to be in a potentially vegetative state. When someone's hypothermic, you have to warm them up in order to establish a clinical status, meaning you can't declare someone dead with a temperature of 80. You have to warm them up slowly, appropriately, and then reevaluate where they are clinically.
I've asked you questions about whether you had an opinion about Mr. O'Keefe and when he died. I want to ask it in the form of a formal opinion. Do you have an opinion to a reasonable degree of medical certainty whether Mr. O'Keefe died immediately or within 15 minutes?
No, I don't think he died immediately. Neither the hypothermia nor this kind of head injury would kill you immediately in any clinical experience I have.
Dr. Wolf, thank you.
That's it?
All right.
I was expecting more. I was expecting a lot more. I thought we were going to be there for a lot more and try to get a lot more from this guy. That was awfully short for my expectations. I thought this guy was basically going to stay on the stand and prove the entire case through medical testimony. What I sort of got from that is that John O'Keefe fell on the ground, and that probably caused a lot of his injuries. That really does nothing to say that the reason he fell on the ground was because of the car hitting him, as opposed to some other reason. So, yeah, I mean, Okay, that's what I got out of it. I don't know if anyone else got anything out of it, but all I got out of it was John O'Keefe had injuries to his skull and brain that are consistent with him hitting the ground. That's basically. Was there anything more from that medically that I was supposed to get? Because that was the extent of it. Did I miss something? Is that it? Rose, did you get anything more of substance than that? Or was basically all that really he said was, yeah, John O'Keefe probably hit the ground and that's probably what caused the brain skull injuries? Because was there anything more than that? Yeah, I mean, like why he fell and hit the ground is completely unspecified by what he said. That was completely unspecified. Yeah. Yeah, that's what I got. Okay, just wanted to make sure I hadn't missed something. All right, cool. I'm not a medical expert, so I wanted to double check to make sure that I'd heard it correctly.
May I, Your Honor?
Yes.
Morning, Doctor. I don't think we've had the pleasure of meeting. Welcome.
Thank you.
Sir, can you just describe, you started to do it a little bit on direct, a typical day for you?
I wake up at 4:15 in the morning. I go to my center. I set up patients with frames for their either radiosurgical procedures or stereotactic craniotomies. I go home. I make cappuccino for my wife at 6 o'clock in the morning. And then I get back to work at 6:30 and move on. I have patients that I'm operating on, and I have patients that I'm seeing through the day.
And what type of patients and what type of work? Just in a typical day. What are you doing? What type of patients and what do you do?
It varies. I mean, I see patients with brain tumors. I see patients with hydrocephalus, which is water in their brain. I see pediatric brain tumors. I see subacute and chronic subdural hematomas, post-traumatic. I see patients with strokes that are being misdiagnosed. I see patients with cancer, metastatic disease. I used to see patients with cervical problems. I stopped doing that 2 years ago. I mean, I don't know what else you want me to tell you.
No, that's great. And is that typical day, typical of the type of days you've had for the past month, past few years? Is it generally, without specifics, is it generally?
Correct.
So, none of your typical days, none of the past typical months have involved forensic pathology, have they? You haven't acted as a forensic pathologist in...
I am, if you could have asked that question, very straightforward. I am not a forensic pathologist. I'm a brain surgeon.
Right. And you don't perform autopsies, correct, sir? You're a brain surgeon.
Correct. In other words, I see more brains than the forensic pathologist.
Right. And is it correct to say that the brains that you see are of living people?
Correct.
Okay. So what I'd like to do is to go to a different part of the head than was discussed, but sticking with the decedent.
Excuse me, I didn't hear the last word.
I'm sorry, the topic is going to be Mr. O'Keefe, the decedent in this matter, sir. You testified about raccoon eyes. The medical term for that, sir, is ecchymosis, right?
Correct.
And ecchymosis, raccoon...
Why do the doctors have to complicate it? Why can't they just call it raccoon eyes like a normal person? Why can't that just be the medical term? The medical term is raccoon eyes. Go fuck it. It's just a label. Can we just rename it? I'm petitioning to rename it. The official term is now raccoon eyes. Fuck you.
Raccoon eyes does not cause a laceration to form on an eyelid, does it?
No.
Are you aware that Mr. O'Keefe had a laceration to the outside area of his right upper eyelid?
I am aware that the ME described that. Yes, sir.
Now, could, Your Honor, I'm going to, with Your Honor's permission, ask to publish what is already in evidence in a moment.
Okay.
Mr. Wolk,
What exhibit number, Mr. Alessi?
we're going to, 165, Your Honor?
Okay, go right ahead.
Thank you. Dr. Wolf, have you seen this photo depiction before today?
I believe I have.
Is it correct that that injury on the upper right eyelid is caused by the application of force directly to that area of the front of the head, again, namely the upper eyelid?
That's possible, yes.
Is it more than possible, is it probable that that injury was caused by the application of force directly to that area of the front of his head?
Well, an easy answer to that would be is that that's not part of the periorbital ecchymosis.
Thank you, sir. That was exactly going to be my next question. This injury is unrelated to any of what you've been describing, the fall backwards, the force transfer inside the skull, the, as you described it, the dura, the cerebral spinal fluid, all of that dynamic that you so ably described on your direct examination. This injury has nothing to do with that, correct?
Correct.
Brain squishy. Protect brain. Skull's not hard enough. Damn evolution. Needs stronger skull. Stupid skull's not strong enough.
Thank you for answering my questions, Dr. Wolf. A pleasure again.
Really? That's all there is on Cross? This is like the shortest expert witness of all time. Oh, okay. I guess that's the end of the cross-examination period. All right.
No more questions at this time, Your Honor.
Any brief follow-up on that?
No, thank you.
Okay, well, that's the end of that witness. All right.
Thank you very much.
That was surprisingly short in every possible dimension.
Mr. Brennan?
May we have a moment to inquire of our next witness?
Sure. And while I see counsel outside our jurors, feel free to stand up and stretch.
He has surgeries. Yeah, well, be that as it may. I mean, I expected a lot more from this witness. I expected this witness, the brain surgeon, to basically, on Cross, I don't know whether or not you could ask him, but I don't know whether or not you could ask him the question in some form. Did you see any injuries that would be consistent with a car hitting him 25 miles an hour? I don't know if there's some way of asking that question that would make sense, but, for the prosecution or the defense, right? Because someone doesn't want that question asked. I'm not sure who doesn't want the question asked, but someone doesn't want the question asked. So, why neither of them asked the question is slightly surprising.
So, jurors, you may realize that that went quicker than we thought. So we are ahead of schedule, so why don't we take that morning break that we can take? So we'll take a 15 or 20-minute break.
All
Yeah.
rise for the court, please.
So I would have expected either the prosecution or defense to ask the question in some form. Were the injuries you saw consistent with a car hitting this guy 25 miles an hour? If the answer is yes, then, great for the prosecution. If the answer is no, great for the defense. But neither of them asked the question. I don't know if because neither of them wanted the answer. I don't know if it was too ambiguous maybe the answer is it's too ambiguous for either one of them. Maybe the prosecution doesn't want the answer because the answer isn't certain enough, and the defense doesn't want the answer because the answer is not certain enough. Maybe that's it. But I was surprised that we didn't try to do a lot more with that witness than we did. Because, he is a literal brain surgeon, so he knows everything, right? So, You think Brendan's trying to throw the case? I don't know if Brendan's trying to throw the case. If you're trying to throw the case, I think there were other ways. I think he could do it. I don't know if I agree with that assessment, but yeah, Brendan has to prove it did happen. I understand. That's my point, right? He doesn't want to ask the question because the answer is too ambiguous for him. But the defense also doesn't want to ask the question because it's too ambiguous for them. Right? It's like so neither one of them are really thrilled with the answer. I mean, that's the most plausible contention. Either that or the defense doesn't know what he would say, and therefore you don't ask the question because you don't know what he's going to say. So if you don't know the answer, you definitely don't ask the question. Yes, still no evidence of a collision with the car. Yeah, I tend to agree, Josh. That's by far and away do all the logs you want trying to prove the car was there at the time John O'Keefe was there. Try to bring in the fact that she's drunk. Try to bring in the fact that she's angry. Try to bring in the fact that, try to bring in all this motive and stuff. But if the car doesn't hit him, then, whatever. So also, if the answer were ambiguous and Hank were trying to throw the case, then Hank would ask the question. Because if the answer is, like there's really no way for me to know, or it's too ambiguous, or I don't know, if he would ask the question if the answer were potentially harmful, if he were trying to throw the case. If prosecution wanted the defense to open certain doors and they didn't, well, the defense definitely isn't going to ask the question if they don't know the answer for 100%. Because lawyers don't ask questions they don't know the answers to, especially if experts they don't control. So if you don't know the answer, you definitely don't ask the question. You're not going to ask that question just out of raw curiosity because God knows what he's going to say. But yeah, I still think there's really no evidence that she hit him with the car. That continues to be the weakest part of the case by far and away. It goes back to the question I've posed many times. Like for me, the easiest way to resolve the case remains the easiest way to resolve the case. How does a car going 25 miles an hour hit a guy with enough force to create a disabling injury, but not enough force to create broken bones, bruised, torn ligaments, or even a bruise? How are both those things possible at the same time? That is the easiest way for me to resolve the question, right? And everything else is moot, right? Everything else doesn't matter. If she was literally there at the exact same time, if she drove backwards in a drunken stupor at exactly when the prosecution said, if all those logs reflect Karen Reed driving back at exactly the time that John O'Keefe happened to be on, and if all those things are if all those things are temporally concurrent, without the causality, who the fuck cares? Right? Just because John O'Keefe was there and Karen Reed was there, or John O'Keefe was there, therefore Karen Reed did it, doesn't do it for me. So if you spot the prosecution, everything else, it just doesn't matter. right? It just, if you spot them, everything else. She had the motive to kill. She was jealous. She really believed that, he was having an affair, and she was drunk, and she lost her temper, and she drove back at 25 miles an hour at 12, whatever it was, in the morning. And she drove back, and if you spot the Commonwealth, everything, right? If you spot them, all those things, you're still back to the easiest way to resolve it. How does the car create a disabling injury without creating those other injuries? How is that possible? And it's like, it's just not possible to my mind. And again, like, even assuming it's medically possible, because everything's possible in medicine, everything's happened once, right? Even assuming it's possible, how is it sufficiently plausible to be reliable enough for me to get to use it in a beyond a reasonable doubt analysis? I'm not saying it necessarily has to be beyond a reasonable doubt by itself, but it has to be at least plausible enough for me to throw it into the equation. Whatever that threshold is, I'm not sure, but whatever the threshold is, they haven't met it, to my mind. And without that essential element of the crime, you're missing the actus reus, or the causality, right? You're either she didn't hit him at all, or she didn't create a disabling injury. And it's like, take your pick between the two. It doesn't really matter, because either the act didn't happen, or she didn't cause the death from the act. So either the act is missing or the causality is missing. Either way, you're missing an essential element of the crime, and you're done. Without the essential element, you're done legally. It's like, we can move on with our lives. It's like, and we don't have to worry about anything else. And now, assuming that you solved that problem, I'm not necessarily saying you have beyond a reasonable doubt. I'm just saying it's the easiest way to say there's doubt. It's the easiest doubt to show. If you solve that problem, we could move on to other questions. But until you resolve that question, there's no point in moving on. There's no point in, let's resolve all the other questions, because I'll just spot you everything, right? I'll just spot you everything. I'll spot you every other issue, so we can discuss this issue, right? And it's like, can we please discuss this for a while? And until you convince me it's sufficiently plausible, there's no point in us moving on. And if you can't convince me it's sufficiently plausible, nothing else matters. And that's what I think. Right? And again, like, I don't have to prove anything within the confines of this case. I don't have to prove who killed John O'Keefe. I don't have to say who did it. I don't have to say if there's a conspiracy. I don't have to do anything. I can even spot you that Karen Reed did it. That's the real trick. That's the real trick, right? I can spot you Karen Reed did it, because that's not the question. The question isn't, did Karen Reed do it? The question is, can the state prove it? That's the question. So if you want to say Karen Reed did it, I'll spot you. I'll spot you Karen Reed did it. But can the state prove it? No. Therefore, we're done. Right? That's how much nothing else matters. And in a legal sense. This is also why the question matters so much in law. A theme that I try to hammer to you a lot in a lot of different domains. I try to hammer the point. The question matters a shit ton, because the question drives the entire analysis. The exact question that's being asked legally is incredibly important. And when you understand the question that's being asked, it can focus and resolve other issues, right? And it just makes your lives easier. It just makes your lives easier. Does that mean Karen Reed gets away with murder? Maybe it does. See, this is why, again, these questions clarify. Does it mean Karen Reed gets away with murder? Maybe that's what it means. But, if the state can't prove it, that's what it's supposed to mean. Karen Reed getting away with murder in that situation would not be a bug. It would be a feature of our system. See, that's the thing. Like, that's what's supposed to happen. because the state can't prove it, because it's the state's burden. And they can't prove it. So we all go home. And we, live to fight another day, and so forth and so on. That's why, like, focusing on the exact question matters so much. And why the exact question that's being asked at any time is so critical. And why lawyers, especially appellate lawyers, spend so much time worrying about the question. Because the exact question you're asking, right? Like, if you're an appellate lawyer in particular, the exact question you're asking matters a lot. It's in some sense, some senses, it's the game. The question is the game. That's how important it is. So it's like, that's why you sweat over the question. Without that, nothing else really makes sense. And then as to whether or not Karen Reed was framed or anything else, I'll leave for someone else to figure out. Not my circus, not my monkeys, man. There is only one question. There is only one question. Keep my eye focused on the ball. There are no other questions. I'm only here for one question. One and done, baby. One question on civil. Just get off my lawn.
Court's back in session. You may be seated.
All right, may we have Ms. Hanley, please?
Questions fill my head. Went to my doctor and my doctor said.
And ma'am, I'll remind you, you're still under oath and to keep your voice.
Oh, she's back. Okay. What do you have to bring to the picture, and why are you back? Who are you again?
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor.
Are you Hannah?
And ma'am, if you could just please introduce yourself to the jury again, spelling your last name for the record.
Sure. I'm Christina Hanley. Hanley is spelled Hanley.
And Ms. Hanley, given the break, if I could just ask you a few questions just to reorient as far as the items that we were speaking about yesterday in your testimony. First, starting with the items of glass that you analyzed in this case. The first of those items was an item 3-2, is that correct?
That's correct.
And if you could, please describe for the jury, or please provide the jury with the description for that item that you received.
Sure. So item 3-2 was a clear glass cup with broken irregular edges.
I understand. Okay, so her testimony was interrupted in order to bring the surgeon on. So we're just resuming her testimony. She's not strictly being called again. She's just resuming her testimony from earlier. Okay, that makes sense. All right, fair enough. All right, carry on.
There was some dirt debris material that was noted on the exterior and interior surfaces.
Your Honor, may I approach?
Yes.
All right. So she's still on the stand for the first time. Okay, cool. All right, that makes sense.
I gave Mr. Jackson my copy, yes, thank you. Showing you a photograph, Ms. Hanley, do you recognize that?
Yes, I do.
And what do you recognize that?
So This is a photograph that I took. It's item 3-2, but it's also, I would have to double check on my notes, but I believe it has item 7-12, one of the pieces that I'm holding, that's showing a physical match between those two items.
Your Honor, call both the seat to introduce in minutes of the next exhibit.
No objection. Okay.
Exhibit 195.
And Your Honor, may I publish?
Yes.
Ms. Gilman, if I could have photograph 9490. Ms. Hanley, what's up on the screen, is that the photograph that I just presented to you?
Yes, it is.
And if you could, please describe for the jury what we're looking at here.
So that is a photograph that I took upon examination. It is the clear glass cup, item 3-2. And I'm holding another piece, which, again, I believe it's one of the pieces from item 7-12. I would need to confirm in my file, but I'm showing that one of the pieces physically fits with item 3-2.
Thank you, ma'am. Ms. Gilman, you can take that down. May I approach again, Your Honor?
Yes.
I'm showing you two other photographs. If you could just look at those, look up when you're finished. And do you recognize those?
Yes, I do.
And what do you recognize those as?
So these are photographs that I took of item 7-12.
Your Honor, call both the seat to introduce and admit as the next exhibit A and B.
Is there any objection? No objection. Thank you.
Exhibits 196A and 196B.
And Ms. Hanley, if you could, just remind the jury as far as the physical description that you received in regard to item 7-12.
Sure. So item 7-12 consisted of some clear plastic pieces as well as 9 pieces of glass with broken irregular edges.
And may I publish, Your Honor?
Yes.
And Ms. Gilman, if I could have first photograph 9476. And if you could enlarge that just a bit, Ms. Gilman. And Ms. Hanley, what are we looking at in this photograph?
So this is the photo that I took of item 7-12 as I received it. So there's the several pieces of clear glass with broken irregular edges.
And Ms. Gilman, if I could have 9477. And if you could enlarge that just a bit. And again, Ms. Hanley, what are we looking at in this photograph?
Those are the same pieces of glass as in the previous photo, just a little bit more up close of the clear glass that was recovered and is item 7-12.
Thank you. Ms. Gilman, you can take that down. Now, Ms. Hanley, as far as a comparative analysis between items in 3-2, the glass cup, and 7-12 regarding the glass pieces, what, if any, conclusions did you make in reference to your comparison between those two items?
Sure. So upon comparing those items, I did note that 6 of the 9 pieces of clear apparent glass had a physical match to item 3-2, the clear glass cup.
And if you could just remind the jury as far as a physical match, what does that mean?
So a physical match is basically if an item breaks and those items have broken irregular edges, if those pieces come back together like a jigsaw fit, then it's a physical match, and they were at one time together as one larger unit.
Now, as far as each of those items within 7-12 had a letter associated with them, correct?
Yes.
And do you recall which of the 6 were a physical match for item 3-2, the glass?
I would just need to refer to my notes for the exact letters.
Sure, you can take your report out and look at it.
The 6 pieces of glass from item 712 that physically fit to item 3-2 were A, B, C, D, F, and K.
But not E, huh? E is no good.
May I approach, Your Honor?
Yes.
What's wrong
Let
with
me ask
E?
you this first, I'm sorry. So, Ms. Hanley,
Not good
during the
enough for
course of
you?
this physical match analysis that you're conducting, are you memorializing that process with photographs as well?
Yes, I am.
May I approach, Your Honor?
Yes.
I'm presenting you with 4 photographs. If you could review those and look up when you finish. And do you recognize those, ma'am?
Yes, I do.
And what do you recognize those?
Those are photographs that I took upon my examination of items 712 and item 3-2.
Your Honor, the combo is introduced and admitted as the next exhibits, A through D.
No objection.
Thank you.
Exhibits 197A through D.
And may I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 9502, please. And Ms. Hanley, what's up on the screen? Can you please describe for the jury what we're looking at in this photograph?
So this is one of the photos that I took of one of the breaks that physically fit together between item 3-2 and item 7-12.
And Ms. Gilman, if I could have 9514. And again, Ms. Hanley, can you please describe for the jury what we're looking at in this photograph?
Sure. So this is a photo that I took when I was doing my comparison of item 3-2 and several pieces from item 7-12.
Now, as far as the individual pieces had sort of little white stickers or labels affixed to them, is that correct?
Yes.
Is that something that you did, or is that something that when the items were provided to you was already done?
So item 7-12, I received those pieces with the labels already on them.
And again, those items, especially 7-12, had been with mixed veneer in your unit prior to coming to your table or your station, correct?
Yes.
Ms. Gilman, if I could have 9518. Again, Ms. Hanley, what are we looking at here?
So this is another photograph that I took of the physical match. It's just another view of the items together of item 3-2 and several pieces from item 7-12.
And lastly, for this batch, Ms. Gilman, if I could have 9520. And again, Ms. Hanley, what are we looking at here?
So this is another picture that I took of the items just slightly rotated of item 3-2 with a physical fit to several items or several pieces from item 7-12.
Ms. Hanley, is there a laser pointer on the desk in front of you?
Yes.
If you could preferably using this screen just so it's visible for the jury, could you delineate where you see in this photograph item 3-2 and where you see the items associated with item 7-12?
So this right here is item 3-2, and these pieces up here are several pieces from 7-12.
Thank you. Ms. Gilman, you can take that down. Now, the other two items that you analyzed or examined in this part of your physical match analysis were items 3-3 and 7-14, correct?
That's correct.
And turning your attention specifically to item 3-3, if you could just remind the jury as far as the physical description of that item that was provided to you.
Sure. So item 3-3 was 5 pieces of clear glass with broken irregular edges that were recovered from the bumper of the vehicle.
May I approach again, Your Honor?
Yes.
Single photograph, do you recognize that?
Yes, I do.
And what do you recognize that?
That is a photo that I took of item 3-3.
Your Honor, Commonwealth seek to introduce in the minutes the next exhibit.
No objection, Mr. Jackson?
No objection, Your Honor.
All right.
Exhibit 198.
And may I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 9446, please. And Ms. Hanley, in addition to the 5 pieces of glass associated with item 3-3, what else is depicted in this photograph?
This is a photo of the 5 total pieces that are from item 3-3.
And in addition to that, is there a ruler depicted in this photograph as well?
Yes, there is.
And what is the purpose of that ruler in the photograph?
It's there just as a scale.
Thank you. Ms. Gilman, you can take that one down. And Ms. Hanley, the last of those items, 7-14, if you could just remind the jury as far as what was the physical description that was provided to you in reference to item 7-14.
Sure. So item 7-14 was a clear piece of glass with broken irregular edges that was recovered from the road.
May I approach again, Your Honor?
Yes.
Again, Ms. Hanley, just showing you a single photograph. Do you recognize that?
Yes, I do.
And what do you recognize it?
This is a photo that I took of item 7-14.
Your Honor, Commonwealth seek to introduce in the minutes the next exhibit.
No objection.
All right.
Exhibit 199.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 9471, please.
So
And again-
the two screens don't match.
No.
Thank you.
Thank you, Your Honor. Ms. Hanley, again, if you could just describe for the jury what it is depicted in the photograph up on the screen.
This is the photo that I took of item 7-14.
Thank you. Ms. Gilman, you can take that down. So, Ms. Hanley, in addition to the physical match analysis that you did between item 3-2, the cup, and 6 of the pieces that you found to be a physical match from item 7-12, did you also compare pieces from item 3-2, 7-12, and 7-14?
Yes, I did.
And what did you conclude in your physical match analysis of those items together?
So upon examining and comparing item 3-2, 7-12, and 7-14, I had concluded that 6 of the 9 pieces of glass from 712 physically fit with item 3-2, and the remaining 3 of the 9 from 7-12 did not have a physical fit to item 3-2. I also compared item 3-2 and 712 to 714, but there was no physical match to item 7-14.
Now, in addition to that, did you also do a physical match analysis between item 3-2, the drinking glass, 7-12, pieces found from the roadway, and certain pieces from 3-3 from the bumper of the vehicle?
Yes, I did.
And what did you conclude based on that physical match analysis between those items?
So upon examining and comparing those items, so there were 5 total pieces of glass from item 3-3. I used 2 of those pieces for physical match comparison to the items recovered from the road. Upon my examination, I did not, there was no physical match between those 2 pieces from item 3-3 to any of the pieces recovered from the road. So that included items 3-2, 7-12, and 7-14.
Now, as far as the 2 pieces that you had selected from item 3-3, do you recall which of those 2 lettered pieces you chose for your comparative analysis?
Yes.
And which were they?
They were pieces A and B.
And if I could ask, why pieces A and B versus other pieces?
So A and B were used for physical match. The remaining 3 of the 5 were not used for physical match comparison due to their size and condition.
Now, those same 2 pieces from item 3-3, pieces A and B, did you then do a physical match analysis between that and 7-14?
I did.
And what did you conclude from that analysis?
I concluded that there was no physical match between the 2 pieces from item 3-3 to item 7-14.
Now, did you also do a physical match analysis between piece E from item 3-3 from the bumper?
I did not. No, not a physical match examination.
Did you do any comparative analysis between a piece of glass E from 3-3 from the bumper and item 7-14?
Yes, I did.
And what did you conclude from that analysis?
So I selected piece E for further examination. I did microscopic examination as well as instrumental analysis, and I did the same microscopic and instrumental analysis to 7-14, and I compared the data, and I came to the conclusion that the piece that I sampled from item 3-3, piece E, was found to be consistent in physical and instrumental properties to the sample that I took from item 7-14.
If you could, Ms. Hanley, could you please explain to the jury when you say instrumental analysis, what is that? What does that consist of?
So the instrumental analysis that I conducted was on the Grimm instrument, which measures the refractive index of the samples. So after I had ran my samples for both item 3-3 and 7-14, I compared the data to determine whether they were consistent or not consistent.
And so when you say that something is consistent in instrumental properties, what does that mean?
So in this instance, they had consistent refractive indices.
Now, in addition to that comparative analysis for the glass items, what other additional examinations did you perform in this case?
Sorry, could you say that again?
In addition to items 3-2, 3-3, 7-12, and 7-14, what other items did you look at in this case?
So I also examined item 3-1 and item 7-18.18.
And what was the description provided to you in reference to item 3-1?
3-1 was a tail light, and there were also some other plastic pieces as well.
And taillight from the same vehicle as the glass from the bumper, correct?
Yes.
May I approach, Your Honor?
Yes.
We have another single photograph. Do you recognize that?
Yes, I do.
And what do you recognize that?
This is the photo that I took of item 3-1.
Your Honor, the Commonwealth is seeking to introduce in the minutes of this exhibit.
No objection.
Thank you.
Exhibit 200.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have photograph 9394. And Ms. Hanley, do you recognize what's up on the screen as exhibit 200?
Yes, I do.
And what do you recognize it to be?
This is the photo that I took of item 3-1.
And what's contained in here, is that a fair and accurate portrayal of what the item 3-1, the taillight housing, looked like when you received it?
Yes.
Now, as far as, and we'll get to this more a bit in a moment, but as far as any sort of comparative analysis that you did with any other item, what part of this taillight housing were you comparing to that other item?
So there were clear and red plastic portions of the taillight that appeared to be broken. So I sampled portions of the clear plastic as well as the red plastic on the taillight.
And just for clarity purposes, if you could with the pointer, as far as which of these pieces up on the screen were you sampling the clear and or the red plastic from?
So the red plastic that I sampled was from this area. It's a little hard to tell from here. I think I'd have to refer to my photo in my notes, but I think there were a couple of different areas that had clear broken plastic. I think this might have been one of the areas that was broken that I sampled.
And just for my purposes, really what I'm asking, Ms. Hanley, is the clear plastic that you used from item 3-1 was from the housing unit itself, the large piece, correct?
Yes.
Okay. Ms. Gilman, you can take that down. Now, the other item that you were comparing this to was item 7-18.18. Is that correct?
Yes, that's correct.
And what was provided to you as the description of that item, 7-18.18?
So 7-18.18 was debris that was collected from two pieces of clothing from the victim.
And specifically, that would be 7-17, an orange T-shirt. Is that correct?
I believe that is correct, yeah.
Okay, as well as 7-18, a gray long sleeve shirt. Is that correct?
Yes.
And when you say that item 7-18.18 contained debris, what did that debris consist of?
So the debris consisted of one clear piece of plastic, as well as several pieces of red plastic, among some other trace material.
Now, were there measurements taken of those items within the debris, specifically the clear plastic and the red plastic?
Yes.
And what were those measured to be?
I would just need to refer to my report for that.
Okay, go ahead.
Thank you. Okay, so the clear piece of plastic in 7-18.18, it measured approximately 1/8 of an inch by 1/16 of an inch. And then I measured the largest and the smallest of the red plastic pieces. And the largest piece of red plastic measured approximately 1/16 of an inch by less than 1/16 of an inch. And the smallest piece among those measured approximately less than 1/16 of an inch by less than 1/16 of an inch.
And so those particular pieces that you measured, about how small are we talking about?
So the largest, for the red plastic, the largest piece measured, just for visual purposes, it's roughly like the size of a grain of rice. The rest of the pieces were smaller than that.
And who within the lab provided that debris in that taillight housing to your unit, to the trace unit?
So the debris from the clothing was transferred to my unit by Maureen Hartnett, and the taillight was submitted to the lab by Trooper Christopher Moore.
May I approach, Your Honor?
Yes.
Showing you a series of 5 photographs. You could review those and look up when you're finished. Generally speaking, Ms. Hamden, do you recognize what's depicted in those photographs?
Yes, I do.
And what do you recognize those?
Those are the photographs that I took of 7-18.18.
I'm going to call both the seat to introduce and admit as the next exhibit, A through E.
Thank you. It's 201 A through E.
Your Honor, may I publish?
Yes.
Ms. Gilman, if I could have photograph 9352. And Ms. Hanley, what is depicted in this photograph on the screen?
So this is one of the photos that I took of 7-18.18. This is how I received the clear piece of plastic.
And is that a tin that it's encased in at the time that you receive it?
Yes.
Ms. Gilman, if I could have 9355. And what is this, Ms. Hanley?
So this is a photo of the clear piece of plastic that was within that tin.
And Ms. Gilman, if I could have 9364. And Ms. Gilman, if you could enlarge this just a bit. Maybe just a little more, please. Thank you. And Ms. Hanley, what are we looking at in this photograph?
This is the photo that I took of the debris that was collected from the clothing items.
Ms. Gilman, if I could have 9366. And again, Ms. Hanley, what are we looking at here?
This is a photo that I took under a microscope of the red plastic pieces that I noted within the debris.
And lastly, Ms. Gilman, if we could have photograph 9369. And Ms. Hanley, what are we looking at here?
This is a picture that I took of the red plastic pieces that I removed from the debris.
Thank you. Ms. Gilman, you can take that down. Now, Ms. Hanley, in reference to your comparative analysis from item 3-1, the taillight housing plastic, to the clear and red plastic pieces of debris from debris from item 7-18.18, the clothing of Mr. O'Keefe, what types of instruments did you utilize in this comparative analysis?
Sure. So after completing my examination, I utilized a comparison microscope as well as a polarized microscope, a FTIR, which is a Fourier transform infrared spectrometer, and I also used a microspectrophotometer, also known as a microspec.
And what is a microspec?
So a microspec is an analytical tool that we can use to examine samples that have color. So it provides information on the sample's dyes and pigments.
And how is that utilized in your comparative analysis?
So I ran samples from both items that I was comparing, and I compared the data from those two items as a part of my comparative analysis.
And when you run that sort of data, can you describe for the jury sort of what that data looks like? Like what are you physically seeing when you're examining the data from a microspec?
So what we refer to it as a spectrum or just a graph, and when we do the comparison, we can overlay those spectra or graph to determine if they are consistent or not consistent.
And I know you spoke a little bit about it in your testimony yesterday, but if you could remind the jury as far as an FTIR, what is that and how is that used in your analysis?
So an FTIR is another analytical tool that we can use. A sample is exposed to infrared light, and it reacts in a certain way with that light. And what's produced is a spectrum of peaks and valleys that are representative and unique to your sample. And so that instrument was used to run samples from both items, and then the data was compared from both items.
Now, from your comparison of starting with the clear plastic from the debris from Mr. O'Keefe's clothing, from your comparative analysis of that clear plastic to the clear plastic from item 3-1, the tail light, what did you conclude?
So the clear plastic from the debris was found to be consistent in color and instrumental properties to the clear plastic from the taillight. So accordingly, the clear plastic from the debris could have originated from the clear plastic from the taillight, or from another source with the same characteristics.
And with reference to the red plastic from item 7-18.18 from Mr. O'Keefe's clothing, in your comparison of that red plastic with the red plastic from the passenger side taillight of the defendant's vehicle, item 3-1, what did you conclude from that analysis?
So the red plastic that I sampled from from the debris from the clothing from 7-18.18 was found to be consistent in color, microscopic appearance, and instrumental properties with the portions that I sampled from the red plastic from the taillight. So accordingly, the red plastic from item 7-18.18 could have originated from the red plastic that I sampled from the taillight or from another source with the same characteristics.
I'm sorry, Your Honor, if I could just hold on 1 minute while the sirens pass. May I approach again, Your Honor?
Yes. Actually, is this a good time to take a break, Mr. Lally? Luncheon break?
Entirely up to the court. I probably have another 3-4 minutes left.
I'm going to see counsel for 2 minutes, folks.
Okay. More sidebar time. If he has 3 or 4 minutes, like, why are we just let him ask his questions and then I don't know.
Like I told you earlier, we're ahead of schedule, so we will take a luncheon break, and we'll take an hour. So I know we'll take an hour, okay? We'll see you back again. So, we're just going to follow.
We're taking a whole
All
hour?
rise to the court, please.
Okay.
Jurors, close your notebooks, follow me.
Spinny fan is spending, though. That's nice. Oh, we did hit 600 likes. How nice. That means it's time for a merch giveaway. We hit 600 likes. We hit 608 before the lunch break. So you guys just made the cutoff. You guys cut it close on that one, though. You guys cut it close. But we hit 600. We hit 608. So it's time for a merch giveaway. Cool. Let me set it up. Let's see. Aha, this one is definitely the one we need to have for today. 100% is the one we need to do for today. Oh, and I also wrote rules, which I need to do the bot for. So give me a second. I need to set this up. We will do a merch giveaway. I need to set it up, and I need to finish the rules, and I need to upload them. And give me a second. Give me a minute. We'll do the giveaway. Hold on, please. Should have done this earlier. Oh well. Yes. Now's good. Talk amongst yourselves. Let's see. Okay, let's see. It's going to be here. It's going to be here. It's going to be here. Okay. Now I need to do this. Now I need to do this. Need to do this. Copy this. Do that. Close this. Okay. I need to open a new window so I can get the bot going. Create the trigger inside the bot so the bot knows what to look for. Okay. Okay, trigger phrase is ready. All right, now let me finish up my rules. Okay. Okay, that looks okay. Let's see. Now I need to make this. Now I need to create. All right. I need to share the link. Anyone with the link can view. Okay, great. All right. Now I need to create a command so that you can get it. Okay, I'll create it inside Nightbot because that sounds like a reasonable place to do it. Okay. Let me make this a tiny URL because it will be cleaner. Shorten URL. Great. Copy that. Great. All right. Let's see. Create that. Okay. Let's see if this works. There we go. It did work. All right, great. Official merchandise giveaway, official rules. Void, and you can now see the rules by typing the command !rules, which provides the official rules so that, they're clear. Void where prohibited. Rule 1, void where prohibited. Rule 2, you must be a subscriber to enter. Paid membership is not required, nor does it provide any advantage. Drawing is at random using the giveaway feature built into Nightbot. Rule 3, uncivil law will provide you a phrase that must be typed into the chat in order to enter. The phrase must be typed into chat exactly as provided by uncivil law. Variants or typos will not count. Rule 4, 1 entry per person. Rule 5, winners must send an email to kurt@uncivillawllc.com before 5 p.m. Eastern Time, the same day the contest runs. The email must include the winner's YouTuber username. The email must include the item or items from the Uncivil Law merchandise shop located at uncivil-shop.fourthwall.com the winner wishes to select. The total price of the item selected must not exceed $20. If the winner fails to send the email by the deadline, fails to designate the items, or if the price of the designated items exceeds the $20, exceeds $20, the winner forfeits any prize. Those are the rules. I need to correct a typo. So let me correct a typo so that it will be, typoed. There we go. That corrects the typo. So I'll reread the rule. Rule 5, winners must send an email to Kurt at Uncivil Law before 5 p.m. Eastern Time, the same day the contest run. The email must include the winner's YouTube username. The email must include the item or items from the Uncivil Law merchandise shop located at uncivil-shop.fourthwall.com the winner wishes to select. The total price of the items selected must not exceed $20. If the winner fails to send the email by the deadline, fails to designate the items, or if the price of the designated items exceeds $20, the winner forfeits any prize. Those are the rules. Great. And the rules can be located at !rules. Okay. So that's all clear, I hope. Okay, now I need to go into I need to go here and get the phrase for today. Okay. Cool. Are we ready? Are we ready for the thing? Any other issues I need to solve before I run this contest. We're all good? Everyone happy? All right, let's give this thing a shot.
Sidebar giveaway.
Okay, the phrase is tune in for Vinny later is the phrase. Tune in for Vinny later because later today we will be doing an interview with Vinny from Court TV. So in honor of him, the giveaway phrase is tune in for Vinny later as provided by me. I have given you the phrase in chat verbatim. You can copy paste it if you like. That's how you enter. While you are entering, let's look at some of the exciting items you can win if you wish. All right, let's look at some of the exciting items you could win. Welcome to the Uncivil Law merch shop, where all your exciting merch items and dreams can come true. Callie the Bee Fish welcomes you to the Uncivil Law merch shop. Callie the Bee Fish thinks that you're awesome. You could buy an unexpected black hole mug because that unexpected black hole can cause all kinds of temporal and gravitational paradoxes at 34 Fairview. The unexpected black hole solves many problems. We also, of course, have the sidebar drink glass, whiskey glass, which sounds increasingly tempting as this trial goes on. Of course, we have for you wine lovers the sidebar wine glass, if you would prefer. Doesn't necessarily have to be wine. You could put margaritas in there, a little sangria, it's up to you. You could do many things, a gin cocktail, whatever. We got some mugs, shirts, stickers, Spinny fan merch. We got Pocket State mug, Pocket State shirts, Don't Be a Dick merch. Evidence Solo Cup, Chronic Butt Dialer, House Long to Die in Cold, sticker, You Are Muted, You Are Unmuted mug, Mantra buttons. Got some mouse pads, those are pretty cool. Evidence Collection sticker cups. Of course, the Evidence Solo Cup, ever popular for all your evidence collection needs. Purple statement mug. One of our recent winners decided to get this mug. Was one of our recent winners won this mug. Is what they decided to go with. We got t-shirts. We got a hat. I don't think the hat is cheap enough, but there's some items there. Got a cowboy shirt. Got some stickers from Cali. You could be like a Be on Uncivilian travel mug, Uncivil Law cowboy hat mug, sticker, Cali the Bee Fish stickers, all that good stuff. The chat currently trying to decide when it says to type in the phrase exactly what that means. I didn't know there was ambiguity apparently in that, but apparently the chat trying to decide what that means for some reason. I'm not sure how they found ambiguity in that, but 97 of you are currently entered. We'll give you a chance for a few more of you to type it in. $98 of you currently entered. All right, we'll do a minute countdown. And then we'll do a drawing. All right. You now have 1 minute to enter before the drawing comes to a close. The timer is running. 1 minute left to enter the contest. You counted 400 entries. Did you count people more than once? What about one entry per person was ambiguous in the rules? How many people did you count? All right. And our winner is Davy Cakes is our winner. Davy Cakes is our winner. Congratulations, Davy Cakes. Information relating to how to redeem your prize is contained in the official rules. Please do those things and you can win. So thank you very much, Davy Cakes, for your viewership participation. Okay, well, I guess we're going to take a break. So, again, if you need the information on how to redeem your prize, it is contained in the rules. !rules will give you the link to the document, which will give you the information of what you need to do to redeem your prize. So please make sure to do those things. The rules say the phrase must be typed in a chat exactly as provided by uncivil law. And I provided you the phrase. If you go into the chat, I provided you the phrase exactly as it needs to be done, which was in all lowercase. So I provided you the phrase in all lowercase as I said I was going to do. So don't bitch at me that you can't read and don't understand the rules. I provided the rules. I told you exactly what the phrase was in the chat. And I even told you could copy and paste it so that you would have it exactly. Some of you guys are just unable to read or something. I don't know. It was in all caps, not provided by me. It wasn't. Go read the chat. It was not provided by me in all caps. It was provided all lowercase, Dave. Do I need to ban you? I will. I provided it in all lowercase in the chat. I said you could copy and paste me to make sure it was clear. There was no ambiguity. When I type rules, it just pops up to block a report. I don't know what the fuck you're talking about. So I don't know what you're talking about. When it types up to blocker, what the fuck are you talking about? No, Nightbot will give you the link. What the fuck are you doing? Did you block Nightbot? That's not my problem. If you blocked Nightbot and are unable to see the rules because you blocked Nightbot, that's a you problem. The rules are contained in the yeah. If you blocked Nightbot, that's on you. Maybe you shouldn't do that. Can't copy paste on mobile. Well, first of all, I don't know whether or not you can. Second of all, I didn't say you had to. I said you could. You could just type it in lowercase. That would also been fine. I don't know what the problem is. I just don't. I don't get it. I mean, the link is right there. Nightbot. It's right in chat. Merch giveaway official rules with the link. It's not. It's right there. It's right there in chat. So, what more do you want? I even typed it up so it wouldn't be ambiguous. And people are still unclear. I don't know. I can individually select people to not be in the contest. That's cool. I didn't even know I could do that. I could theoretically. I wouldn't, but I could. I can individually remove people from the contest. That's funny. I should put that in the rule. People who complain about the contest are not eligible for the contest. I'll put that as a rule in the future. I like that. People who complain about the contest are not eligible to win. Is it lunchtime? It might be lunchtime. All right. When is the court coming back again? 2 p.m. or 1 p.m. a half hour? Trooper Proctor is more than welcome to enter our contest as well. If Trooper Proctor is in chat, he is more than welcome to enter the giveaway. Trooper Proctor might enjoy a sidebar glass or something. He might enjoy the evidence collection cup. Maybe he can present it to his former coworkers, and they can use it for their evidence collection needs. If my merch evidence cup winds up being featured in a future trial, I'm coming after one of you guys. I don't know who it is, but one of you guys, we're having a conversation. But Trooper Proctor, if you're out there, you're more than welcome to also enter the giveaway. Everyone can enter the giveaway. It's good for everybody. All right, guys. I will see you in 30 minutes or so, I guess, whenever the court comes back.
Thank you. This court's back in session. Please be seated.
Whenever you're ready, Mr. Hanley.
Thank you, Your Honor. Now, Ms. Hanley, when we left off, you were discussing the comparative analysis you did between item 7-18.18, Mr. O'Keefe's clothing, and item 3-1, the taillight housing or the plastic within the taillight housing of the defendant's car, correct?
Correct.
And there were a number of different instruments that you used through the course of your examination and analysis, correct?
That's correct.
And what were those instruments that you used again in that portion of the analysis?
Sure. So I used a polarized light microscope, a comparison microscope, an FTIR, and a microspec.
And Your Honor, may I approach?
Yes.
showing you 3 documents. If you could review those with up when you finish, please. And do you recognize those?
Yes, I do.
And starting with the first page of that 3 pages, what do you recognize that?
It is the FTIR comparison data for the clear plastic from item 3-1 and the clear plastic from item 7-18.18.
And if I could direct your attention to the second page within that, what do you recognize that?
So this is also FTIR comparison data from for the red plastic from item 3-1 and item 7-18.18.
And lastly, the third page within that set, what do you recognize that?
So this is the comparison data from the microspec from the red plastic from the item 3-1 and the red plastic from 7-18.18.
Your Honor, the Commonwealth will seek to introduce and admit as the next 3 exhibits individually.
No objection, Your Honor.
All right, thank you.
Do you want them marked individually, or do you in a set?
Individually, please. Thank you.
Exhibits 202, 203, and 204.
Thank you.
And again, Ms. Hanley, when it came to your analysis of the clear plastic material from the debris from John O'Keefe's clothing and the clear plastic material from the defendant's taillight, what were your conclusions from that analysis?
Sure. Upon comparison, the clear plastic from item 7-18.18 was found to be consistent in color and instrumental properties with the clear plastic from item 3-1. Accordingly, the clear plastic from 7-18.18 could have originated from the clear plastic from item 3-1 or from another source with the same characteristics.
Thank you. Your Honor, may I publish, and I'm sorry, I forgot already the
Yes.
exhibit numbers, but
Yes.
Ms. Gilman, if I could have the clear plastic. And Ms. Hanley, can you describe for the jury what we're looking at in this, what's up on the screen right now?
Sure. So this is the FTIR comparison data of the clear plastic from item 3-1 and the clear plastic from item 7-18.18.
And Ms. Hanley, if you could, using the laser pointer before you, if you could direct the jury's attention to which is which as far as the top and bottom here.
Sorry. The top,
I'm sorry, I apologize, Your Honor.
That's okay.
Was that someone's ringtone? Hilarious. Let's listen again.
Sorry, I apologize, Your Honor.
That's okay.
the top spectrum is item 3-1, and the bottom spectrum is item 7-18.18.
And Ms. Hanley, when you're comparing these two as far as the data that you receive, what is it specifically that you're looking at in your comparison as far as the data is concerned?
So when I'm comparing the spectra, I'm looking at the peaks in each sample to determine if they are consistent or not consistent.
Thank you. And if I could turn your attention to the red plastic material from the debris from Mr. O'Keefe's clothing and the red plastic from the passenger side taillight of the defendant's vehicle, what did you conclude in your analysis there?
So upon comparison, the red plastic from 7-18.18 was found to be consistent in color, microscopic appearance, and instrumental properties with the red plastic from item 3-1. So accordingly, the red plastic from 7-18.18 could have originated from the red plastic from item 3-1 or from another source with the same characteristics.
Thank you. And Ms. Gilman, if I could have the red plastic data. And Ms. Hanley, directing your attention to the screen again with the laser pointer, if you could delineate for the jury as far as which set of data is associated with which item.
So the top spectrum is item 3-1, and the bottom spectrum is item 7-18.18.
And again, if you could just direct the jury's attention with that laser pointer to the areas as far as the data peaks and valleys that you're looking at in comparison of this data.
So when I'm comparing them, I'm comparing the peaks to each other in each of the spectra to determine if they are consistent or not consistent.
And in this case, you found them to be consistent, is that correct?
That's correct.
And Ms. Gilman, lastly, if I could have the microspec data. And Ms. Hanley, if you could describe for the jury, please, what are we looking at in this particular data set?
So this is the comparison data from the microspec of the red plastic from item 3-1 and the red plastic from 7-18.18.
And as far as the data in any microspec, but particularly this one up on the screen, using that laser pointer, could you illustrate to the jury sort of what these individual lines or what this data means?
So these are the samples that I ran, and they samples that I ran from item 3-1 and 7-18.18, and the spectra are overlaid in order to determine, to look at it and to determine whether they have a consistent or not consistent pattern.
And from overlaying the data from the pieces of plastic from Mr. O'Keefe's clothing and the pieces of plastic from the defendant's taillight, what do you observe as far as from overlaying those two sort of data points?
So I determined that they had consistent microspec data.
Again, if you could just remind the jury as far as the microspec data, what type of data is that?
So the microspec, it analyzes samples that have color. So it provides information of a sample's dyes or pigments.
Thank you very much. Ms. Gilman, you can take that down. Thank you, Ms. Hanley. I have no further questions, Your Honor.
Okay.
Good afternoon, Ms. Hanley.
Good afternoon.
Nice to see you again. We met about a year ago. First things first, you were just talking about some plastic pieces in 7-18.8, correct?
It was 7-18.18.
0.18, I left a 1 out. 7-18.18. We're dealing with a lot of numbers. I'm going to see if we can cut through that here in a second.
Sure.
First of all, you indicated that you were doing a comparative analysis in different, sort of different categorical ways, using microscopy, using the microspec, using the FTIR. I think you also use the FTIR in that as well?
Yes.
And you indicated that your analysis concluded with those pieces could have come from the same source, from the source in 3-1, the taillight. But you're not conclusively saying they did, correct?
It could have come from they could have a common origin, or it could have come from another source with the same characteristics.
Right. So in other words, another way to say that, Ms. Hanley, is it may have come from the taillight, may not have.
It's a possibility.
Okay. I also want to ask you real quick about the taillight manufacturer. You were shown an exhibit, I think it's exhibit 200, and I think we have that available. With the court's permission, we don't have to cut the lights. I think the lighting is just fine. This is exhibit, or a photograph of exhibit 200 that you saw just a second ago. Quick question about that. In your inspection of that taillight, it's true, is it not, that is manufactured entirely of plastic or plasticine pieces. There is no glass in that taillight, correct?
I have to check my notes. I don't think I noted any glass.
Okay. So in other words, you didn't note any glass inherent in the manufacture of that taillight. It's basically plastic.
Yeah, I think most of the parts were plastic. I'm not 100% sure if the entire thing was plastic. There may have been other material, but portions were plastic.
But you certainly didn't see any glass inherent in the manufacture process.
Again, I'd have to double check my notes, but I don't think I did.
Okay.
Do you want her to check her notes?
Why don't you?
No problem.
Are your notes in front of you?
Yes.
With the court's permission.
Yes, sure.
Okay, so I did not make any notation that I noted portions that were glass.
Great. Final point before we get into the actual analysis. On any of the glass, I want to shift gears to just the glass material that you analyzed and that you looked at and you inspected. You saw no blood, no skin, no biological material, no tissue, human tissue or otherwise, on any of those pieces that you inspected, did you?
Upon examination of those items, making observations of those types of material, that's not my area of expertise. I don't think I noted anything that was maybe consistent with that.
So in other words, even though you're not in the bio material expert section of the lab, you certainly would have noted if there was skin or biological material or obvious blood on glass pieces. You were looking at them in many cases through a spherical microscope, correct?
Yes, I would have made note of observations of anything that I would have noted on the surface.
Great, and you did not, because you didn't see anything that was suggestive of that, correct?
I think I just made note, I have to check each item, but I think I did note that there was some dirt debris on some of the items.
But not biological material.
I did not note anything that would be maybe consistent with that.
Great, thank you. I want to talk about the comparisons that you did. And you'll forgive me, I'm a visual learner. So I'd like to talk about it in 4 categories.
Okay.
Linear categories. Category 1, item 3-2. Category 2, item 3-3. Category 3, item 7-12. Category 4, item 7-14. 3-2, 3-3, 7-12, 7-14. Can we talk about them in those particulars?
Sure.
Okay. 3-2 was the cup, correct?
That's correct.
Okay. And I'm going to use the word cup rather than glass for obvious reasons. You could get confused by that. So when I say the cup, do you know what I'm talking about?
Item 3-2.
Great. 3-3 are the 5 items that were found on the bumper, claimed to have been found on the bumper by NSP or the crime. Okay?
Yes.
5 items, A, B, C, D, and E, correct?
Correct.
Item 7-12 are 9 items, glass items, that were recovered at 34 Fairview by Trooper Buchanan in an evidence envelope, correct?
So sustained as to who they were recovered from?
Sure. Did you receive the items along with an evidence envelope?
I need to double check if it was an envelope, but I received it packaged.
Okay. And the packaging normally, under normal circumstances, the packaging comes with labels that gives you reference about where things came from. For instance, when Mr. Lally asked you, were you aware or did you become aware that items were claimed to have been found on the bumper? You didn't actually find those items, but that was the description you were given, correct?
That was the description of the item in our limb system.
Okay. And going back to 7-12, that's our third category, was that described as 9 pieces of glass that were found at 34 Fairview by a sergeant by the name of Buchanan? Or do you recall that?
I am not sure who recovered them.
Well, what it said on the evidence envelope, that's what I'm asking.
I would have to check my photos to see if it says that.
We'll get to that in just a second, but fair enough. 7-12, 9 items, A, B, C, D, E, and if my memory serves, I, K, and L.
I'd have to refer to my notes to.
Can you please?
Yes.
We're going to be here a little while, I think.
So the 9 pieces of glass from 7-12 were labeled A, B, C, D, E, F, I, K, and L.
Great. And then finally, what was in 7-14, that's an easy one, 1 piece of glass.
That's correct.
Okay. Your Honor, may I approach?
Yes.
If I could, Ms. Hanley, I'm going to hand you photographs. That should be 2 photographs of the exact same thing. Do you recognize what's depicted in that photograph?
I've never seen. I did not take this photo.
Understood.
So I'm not. I haven't seen them, so I don't know.
So I'm asking you to look. I know you haven't seen
Yeah.
that photo. Does it look like the cup?
It looks consistent with the cup.
Okay. Just gonna set this one aside for a second. Take a look at the second photo. Do you recognize what's depicted in that photo?
I did not take this photo. It appears to be a photo of a container that another analyst took a photo of item 7-12.
And item 7-12, once again, included plastic pieces and 9 glass pieces, correct?
Correct.
Do you see the evidence label on the very top of that evidence envelope?
I'm not sure which label you're talking about.
The one under the red tape.
Yes.
Does that appear to be a label marker that's done to maintain chain of custody?
So I think that label, sorry.
Sure, can we bring these over to the side?
Sure.
How you guys doing in chat? Uncivil is definitely running a little low on fumes at the moment, but that's okay. We're going to have a second win pretty soon. That's what I'm going with. It's part of the job and she's bad at it. I don't know. She's not great, but I don't think she's particularly horrendous either. I've seen a lot worse, including from witnesses in this trial. Parsing words. I think she's just trying to be precise. It's challenging because you want to answer honestly, and people are going to harangue you for every word that you say. We've definitely seen that. So the pressure to be precise is pretty apparent. We've seen Jackson in particular crucify people over a wrong word choice. It's like, oh, I didn't understand the question. So the incentives become to be, incredibly precise in your answers and parse the shit out of everything because, AJ will crucify you if you don't do it to some degree. So there's no alternative but to do it. It's like you can't have it both ways. It's like if I ask you a question, I give you an answer, and then you're gonna, crucify me because I wasn't perfect because I wasn't under oath. If you're gonna crucify me, my incentives be like, okay, fine, I'll be perfect. That means this is gonna be tedious. We're gonna parse the shit out of everything. I'm gonna be incredibly exacting. It's gonna take forever because heaven forbid I put a comma in the wrong place. You can't have it both ways. Oh yeah, the poll's old. What happened to hourly polls, Mons? Have you been slipping? I haven't noticed. Yeah. Yeah, if you put me on the stand, right? And I know that AJ, for example, is going to be like, going over my answers with a fine-tooth comb. I'm going to be incredible. I have to be tedious because I have to make sure I'm perfect. So I'm going to have to really define everything and be utterly precise, and it's going to take forever. So it's like, if you want perfection, perfection takes longer.
Jurors, sometimes we're at sidebar in an effort to try and speed things up. So even though we take your time that way, this should make things move a little easier.
So you can cut back, come back up here.
Tony, it isn't all on you. We have other mods that could be doing polls.
We already looked at what's been marked for identification as triple G. I was asking you about what has now been marked as triple H. If you'll just look at that, what I'm most interested in is, do you see a name, a trooper's name, in the middle of that evidence bag?
Yes, I do.
Is that Buchanan?
It looks like it says that, yeah.
Okay, and just so we're clear, that bag is associated with 7-12 of your analysis. The item 7-12, correct?
Yes, again, I didn't take this photo, but I have, yeah.
I realize that. It says 7-12
Yeah.
right on the photo.
Yes, yeah.
That's all I need. Taking a look at what's been marked as triple I for identification. Do you see a name associated with that evidence bag?
Yes.
What name is that?
It's actually a little hard to read. It looks like it says, it could say Trooper Proctor.
Okay, and that is associated with 7-14, our fourth category, correct?
It is labeled as, excuse me, 7-14.
Thank you. And finally, does that, which has been marked as, for identification at least, as triple J, does that appear to be the contents of that bag, which is a single piece of glass in 7-14?
This appears to be the photo that the analyst prior to me took of item 7-14.
And that would be analyst Valier.
Correct.
You see her initials there.
Yes.
Okay, thank you. So the four categories, just so we're clear and we can stop using so many numbers because they can get confusing. 3-2 is the cup, right?
Yes.
3-3 is the bumper glass, correct?
That is correct.
7-12 is the Buchanan glass, correct? You just looked at it,
Yes.
okay? 7-14 is the Proctor glass, the single piece, correct?
Correct.
So when I make reference to those items by those names, you'll know what I'm talking about.
Yeah. Yes.
Hesitant.
No, I just, I'm just used to referring to them to the item numbers, but I will try to stay with you.
My brain will melt if we continue that way.
Can she do it both, Mr. Jackson?
Sure. Any way that you wish. I have another document that I would like to approach with, if I could, with the court's permission.
Okay.
Thank you. I'd like you to take a look at that. You've got a copy of this. Have you ever seen that before, or a variation of it?
Yes.
Okay. Saw it last year, correct? Or something close to it last year?
Yeah, it looks consistent.
Okay.
Okay. If there are any others, Mr. Jackson, why don't we bring all the...
This is it.
Are we discussing what kind of pie we like? Real key lime, if you can get it. Although that's challenging. You get real key lime pie. Bev wants to go home? You and me both, Bev. Is a cobbler conversation? What kind of cobbler is best? Key lime cobbler. Between the options in chat, I guess other then. I'll go with other. Be a rebel. What is a fake key lime? Just regular lime. Just regular lime is fake key lime. Jack Daniels pecan pie. There you go. Margarita lime, rhubarb strawberry, lemon meringue. Meringue in general. Meringue is okay, but I think a bit overrated, all things considered. I wouldn't go out of my way for any kind of meringue. How many pounds have I lost? I haven't weighed myself in a while, but last time I checked, I was down like 65 pounds, give or take. I might be down a little bit more, though. I haven't weighed myself in a while. Still like 100 pounds to go, though, but, you know, any progress is good.
So I think I gave somebody the copy that I was using. I need a copy.
If I may approach?
Yes.
I love the fact how they ask to approach every time.
All right, so let's mark this first for identification.
I know some judges are like, just walk up, it's fine. Some judges don't care.
KKK for ID.
Ms. Hanley, if I could ask you very briefly, I want to go through this chalk with you for a moment. Do you recognize something on the left, looking at the first category? Do you see 3-2?
Yes,
How is that described?
it's described as a cup.
Okay, and you see that there's a photographic representation of the cup just above it, correct?
It looks consistent with,
Okay. Moving to the second category. What category is that?
it's item 3-3.
And 3-3, first of all, there's a photograph above it. Do you see that?
Yes,
It appears to be of a bumper, correct?
yes,
You didn't take that picture.
I did not.
Okay, let's look down beneath it. You indicated that there were 5 items in 3-3, A, B, C, D, and E, correct?
Correct.
Do you see A, B, C, D, and E represented in that category on this chart?
I do see A, B, C, D, E categorized, yes.
Great. Under A, you previously testified that the bumper glass sub A in 3-3 did not match the cup, correct?
That's correct.
Did not match anything in 7-12?
Sorry, just give me one moment. That's correct.
And did not match anything in 7-14?
That's correct.
And you see those represented by sort of the international symbol for negative, correct? A circle with a line through it, correct?
Yes.
Okay. Under subcategory B, glass B, or item 3-3B, did not match the cup, did not match 7-12, did not match 7-14.
That's
Is
correct.
that accurately represented on the chart?
Yes.
Finally, with regard to E as an echo in that same item, 3-3. You see that there is a green indication that glass recovered by Proctor does match, or did match in your analysis, or was consistent with the item in 7-14, correct?
It was consistent microscopically and instrumentally.
Does that accurately reflect that finding on this chalk?
Yes.
Okay, now turning to category 3. There were 9 pieces of glass that you looked at, correct?
Correct.
A through F, I, K, and L. Is that right?
If I could just reference my report to make sure.
Of course.
Yes, those are the correct letters.
And A, B, C, D, F, and K all matched the cup, correct?
Again, I would just need to confirm with my report.
Take your time.
Yes, so A, B, C, D, F, and K
All matched the cup.
had a physical match to 3-2, the cup.
Is that accurately represented on this chart? With green.
Yes.
And E is in Echo, I is in India, and I think that's L is in Lima, did not match the cup, correct?
That's correct.
Okay, is that accurately represented on this chart?
Yes.
And finally, the last category, 7-14, that is the single piece of glass that was recovered by Trooper Proctor. That did not match the cup, and it did not match anything in 7-12, correct? And if you need to check your notes, feel free.
Yes, that's correct.
Is that accurately represented on the chart?
Yes.
Your Honor, I would move for the admission with the amendment that the court indicated at sidebar of triple K.
Okay, I'm going to allow it in.
205.
205?
Yeah.
Your Honor, the court indicated that it would like to see us before anything's published to the jurors.
Okay, come on over for a second. Actually, have those have those been done?
It has been done,
Okay.
and I was going to explain at sidebar.
All right, then come on over. $205.
Thank you. request permission to publish?
Yes.
Ms. Hanley, you see the chalk that's been, or actually what's been marked as Exhibit 205 in evidence on the screen?
Yes.
Is that consistent with what you and I were just talking about at the witness stand?
Yes.
If you'll direct your attention to the screen on the right, just because it's a little easier and I think the laser pointer shows up a little better. Do you see the 4 categories represented in this exhibit?
Yes.
Okay, so 3-2, I'm going to go over it very quickly one more time, just visually. 3-2 on the left is the cup, correct?
Yes.
3-3 represents the 5 pieces of glass of what we call the bumper glass, A, B, C, D, and E, correct?
Yes.
7-12 is the 9 pieces of glass recovered by Trooper Buchanan at 34 Fairview, correct?
Yes.
And finally, 7-14 is the single piece of glass recovered by Trooper Proctor, correct?
Yes.
Taking these one by one, just so everybody see? Taking these one by one, looking at starting with the bumper glass, category 2. Piece A did not match the cup, anything in 7-12 or anything in 7-14, correct?
That's correct.
Piece B did not match the cup, did not match anything in 7-12, did not match anything in 7-14, correct?
That's correct.
And moving over to category 3, there were some matches in these 9 items, 6 of them, A, B, C, D, F, and K, correct?
Yes.
But what those matched, Ms. Hanley, with a cup, nothing on the bumper, correct?
Correct.
And what didn't match the cup were E, I, and L. Is that right?
That's correct.
Moving back to category 2, however, there was one thing, item E, that did match something in this series of categories. Isn't that right?
Not a physical match, but instrumentally there was consistency.
All right. And this was an item, the only piece of bumper glass, the only piece of bumper glass to match anything else in your analysis. Matched what? What was consistent with what?
Item 3-3, piece E, was consistent in physical and instrumental properties with the sample that I took from item 7-14.
Which is the single piece of glass recovered by Michael Proctor, correct?
Yes.
But not a single piece of glass, nothing that you analyzed coming from that bumper matched the cup, did it? Nothing.
Physical match comparison, there was no physical match comparison to the cup.
Are we done with this, Mr. Jackson?
We can take this down, Your Honor. Your Honor, that's all I have. Thank you.
Mr. Riley?
Now, Ms. Hanley, as far as you were asked some questions on cross-examination about biological pieces or tissue or things being on the glass, and you referenced that that was done in another unit, correct?
Yes, if that type of examination was needed, that would be done in a different unit.
Objection, Your Honor.
I'm going to allow that, but next question.
Which unit would that be conducted in?
Objection.
So the objection sustained. You need more, Mr. Lally, before you move on.
Now, as far as the chalk that you were just presented.
Chalk!
As far as the 4 photographs that were depicted in there, have you ever seen any of those 4 photographs before?
No.
Do you know specifically who or where any of the items 3-2, 3-2, 3-3, 7-12, or 7-4 were physically recovered from?
I just have the description that's put in the LIMS system when it's submitted to the lab.
And do you know that 3-2, the drinking glass, was recovered by the Canton Police Department on January 29th, 2022?
Objection.
Sustained.
Do you know that item 3-3, the bumper glass, was recovered by Ms. Maureen Hartnett from your lab on February 1st, 2022?
Sustained.
Do you know that each of the 4 items were recovered by different people on different
Objection,
dates
Your Honor.
at different
May
locations?
we approach?
Yes.
I'm really looking forward to our interview with Vinny. Hopefully, we're doing this soon.
Ms. Hanley, from your conclusions that you testified about before, you found that the item 3-2, the drinking glass, was consistent with 6 different pieces from item 7-12 that were found in the roadway outside of 34 Fairview Road, correct?
That's correct.
And you also found that piece E from item 3-3, the bumper glass, was consistent with the single piece from item 7-14 that was found in the roadway outside of 34 Fairview Road. Is that correct?
Yes, that's correct.
And you also found that items from 7-18.18, the debris from Mr. O'Keefe's clothing, were consistent with the item 3-1, the taillight housing, correct?
Objection, Your Honor.
Sustained is to form.
Now, as far as the chalk that you were presented with on cross-examination, was there anything in there about item 7-18.18 or item 3-1, either the taillight housing or the debris from Mr. O'Keefe's clothing?
No, there was not.
Nothing further.
Anything?
Very briefly. So in sum, not a single piece of glass on that bumper
I'd still date her.
connected to that cup, correct?
Hopefully, she'd answer
there
my
was no
questions
physical
less
match
evasively.
to the pieces that I compared for physical match from the bumper. There was no physical match.
Someone can
to
just animate little
the
hearts,
glass cup,
you know.
3-2.
Cupid over my head or
Another way
something.
of saying that is not a single piece of glass that you analyzed on that bumper matched that cup, correct?
Sustained.
But the one piece of glass that did match something came from the same source, or was consistent with coming from the same source as the single piece of glass recovered on the possession of or bagged by Trooper Michael Proctor, correct?
It was consistent with item 7-14.
That's all.
All right, Ms. Hanley, you are all set. I'm going to see counsel for a minute. Jurors, feel free to stand up and stretch.
I have a sneaking suspicion that the reason she's asking to see counsel here is because the state's witnesses are over. And they're asking, and she wants to ask. I have a sneaking suspicion that was the last state witness. And she's asking about whether the defense is ready to start tomorrow. Could be wrong, but that's my working bet. Let's see if my intuition is right. Not only are they done for the day, I think the prosecution's case is done. I think the case is right. I think the prosecution's ready to rest. Will defense move to dismiss? Of course they will. 100%. You know they will. They'll be denied, of course, but they'll ask. No Proctors or Alberts? Not from the Commonwealth, no. Accident reconstructionist? I think that's being shifted into the case in chief to rebut ARCA. That's what I think. Yeah, I think that's shifted. I apologize. It shifted into the rebuttal case. Not one person from 34 Fairview was called. Facts. I think the state's case is over.
All right, so jurors, I know you don't like it when we're at sidebar. We don't like it when we're at sidebar, but I can tell you that after speaking to the lawyers now, we're ahead of schedule. And they've worked very hard to get us to this point where we're ahead of schedule so that tomorrow, instead of being a half a day, you have tomorrow off. So you have tomorrow and Friday, a good long weekend. It's very, very important. Do not discuss this case with any.
Yep. I don't know if the state's going to say it, but the state's case is over.
Anyone. Don't say a word about this case. Don't let anybody say anything to you about this case.
On the plus side, I get tomorrow off, which is nice. I'm going to the pool.
As well. Have a great long weekend. We'll see you here Tuesday morning, ready to go.
Court, all rise to the jury.
Yeah, why isn't there a half day tomorrow? Why isn't there a half day tomorrow? Or why isn't there a full day tomorrow? What would be the logical conclusion? The state doesn't have anyone left to call. And the defense isn't ready. So the defense picks up Monday. And so the first words out of the prosecution's mouth on Monday are the state rests. That's the logical conclusion. I think the state's case is over. I think we're done.
Goodbye.
I think we're done. I think the state's case is over. I could be wrong. I could very much be wrong. And the state doesn't want to say it till Monday morning, right? If their choice is say it now or say it Monday morning, because once they say it, they can't take it back. So if my choices are say it now versus say it Monday morning, I'll say it Monday morning, Your Honor, right? On the off chance that, somehow I think of something over the weekend, just in case, right? Just in case. But
So no one needs to see me about anything? We get cleared.
Put on the record that what's been marked for as actions that interfered evidence 205.
Tuesday? Oh, Tuesday then? Okay, Tuesday then. More holiday for uncivil.
Yeah.
Exciting.
Get that printed and I think before
Right. I'd like it before we leave. So, before you leave, so. All right. Have a good weekend.
Thank you, board. All right.
Yep. I think the state's case is over. That's what I think. Either that or they have like a really small cleanup witness or something, but I think the state's case is basically over. No court until Tuesday? Don't they say the rest? Well, again, like the state's not going to say it unless they have to. So like if my options are say it now or say it Tuesday morning, if those are my options, I'm going to say it Tuesday morning. You know, because lawyers always like to keep their options open. You know, if all else being equal, we prefer to have the option versus not having the option. So we will try to do things to keep our options open for as long as possible. So if my choices are do it now versus do it Monday, I lose nothing by doing it Monday. So I was like, I'll do it, or Tuesday. I'll do it Tuesday, Your Honor. It's like, fine. Just on the off chance that, I think of something or whatever. But I think the state's case is over. I think that was the last witness. I think that's the end of the state's case. I think that's the end of the state's case. Yeah, nothing from Proctor, none of the witnesses from 34 Fairview. I think that is the end of the state's case in chief. So the state moves to, well, not so much moves, it's just declares that their case is, rested. The defense moves for a directed verdict. Judge says no, call your first witness, and bingo, bango, we're off to the races. Yeah, let me message Vinny here and say, okay. See if Vinny wants to do a stream or what we're doing here in terms of exactly when this thing is supposed to happen. So the interview with Vinny will happen, basically as soon as Vinny's available. Would I put on a case as chief as the defense? Hell yes. Of course I would. Hell yes. And a more robust case than I did the first time. Yeah, absolutely. Yeah, we're gonna be here for the defense case is gonna definitely take a little longer than it did last time. Last time it was like 2 days. This time they're gonna call Proctor. They might call Higgins. They might call Brian Albert. I don't know. They're definitely calling Proctor. I think that's a pretty safe bet. They didn't mention anything about Aruba, which is interesting in the state's case. So maybe they decided to drop that angle. Which, fair enough. Maybe they decided to drop the angle with Aruba. Which, okay, fair enough. I don't think they really needed it for the extra motive. All right. So Vinny says he'll be done by 4, which I presume it's 4 Eastern, so that's 3 my time. So, okay. All right, so I am rescheduling the stream with Vinny for 3 Central. Whoa, let's not do that. And that's, not exact, but it's as close as we're going to be able to get, on this thing in terms of, it's already scheduled for 3 because that's 4. It's 3 his time. So yeah, he's done by 4, which is 3 my time. So it's already scheduled for 3. All right, so it's not going to be rescheduled. All right, great. So we're just taking 50 minutes off. So we'll be back in about 50 minutes, maybe a little bit early, depending on factors. But we'll be back in about 50 minutes, perhaps a touch early, with Vinny Polentane, and we will ask him any insightful questions. I'm going to ask him a lot of questions relating to. I'm basically not going to ask him. I don't think I'm actually going to ask him any questions about Karen Reed because I actually don't care. I think I'm going to ask him questions relating to the state of media relating to court coverage from a historical context going back to the Middle Ages. I'm not even kidding, because I think it's an interesting discussion. I want to know. I want to know basically what his view is of how court has changed as a form of entertainment, over the last 500 years. And I want to know how, in particular, it's been impacted by the advent of television and then also the advent of the internet. How did these technologies change things? And in what ways what ways is it new? And what ways is it the same as it's always been? So it's like, yeah, I'm going to ask him some questions on a 500-year historical perspective. That's what I want to know. So those are the questions I'm asking because it's my fucking interview, and I'll ask the questions I want. So we'll see what he has to say about those things. And I'm going to ask him about podcasts and true crime and, how the media is changing and continues to change, and in what ways it's good and what ways it's bad, and all that kind of fun stuff. So tune in for that. That's going to be fun. Write these down. Don't worry, I've written it down. I've got questions written down. I've got it written down. I've been working on the questions while I've been listening. You've heard me typing in the background a little bit. I've been working on the questions. It's one of the things I've been doing. So yeah, I'm going to ask him about all those things, and that should be fun. Yeah, my contention, and I don't know that I'll ask him this question basically in this way, but my contention is that a lot of the what would you say, the way that people are behaving, let's do that. The way people are behaving relating to trials is not fundamentally new. One of my sort of premises, my conceits, is that I think that, like, people talk about, how, and we'll ask about how television's changed things and how the internet changes things and how social media's changed things. But my contention is that, like, in a lot of ways, the behavior is not new. If we go back to, circa 1500 medieval Europe, people can't read. Literacy hasn't been invented yet. Okay. Literacy hasn't been invented yet. People can't read. People can't write. Everyone is poor. Everyone is poor. Unbelievably poor. Everyone is incredibly poor. So it's like, what do people do for entertainment in circa 1500 Europe? What do they do? I mean, and one of the things they do is go to trials because it's free. The public spectacle of trials is not a new phenomenon. In some ways, it's arguably worse in the past than it is now, because in the past, if you're in a random, European village, you don't exactly have a wide swath of available media to you. First of all, the newspaper hasn't really been invented yet. Second of all, even if it had been invented, depending on what period of time we're talking about, the printing press hasn't been invented yet. So, your media options are somewhat limited. And, you can't go anywhere because travel hasn't been invented yet, right? Because, I mean, no one, so you're basically, you live in your town and you die there because that's sort of and so what do you do? What do you do? Like, people go to the courthouse. That's the public entertainment. And so the spectacle of trials and the spectacle of public execution and the bring us the head of whatever sort of zeitgeist is, at least in my view, a very sort of old phenomenon. It's not a new phenomenon. And so I think that, and arguably in medieval Europe, it's even worse because, no one else can do anything. No one can talk. No one can read. Period. Literacy hasn't been invented. Type hasn't been invented. So no one can do anything except talk about trials because it's all there's. It's one of the things to talk about. People just talk about what's happening. And so the public clamor relating to trials is arguably worse circa 1500 medieval Europe. So that's sort of one of my contentions. So I want to ask him about that in a less, ham-fisted way. But I'd be interested to see what he thinks about the development of, how we cover court in the last, say, 500 years, give or take. So that is, one of the things I think about in my free time. Yeah. So I want to ask, is it new? Is it new, or is everything old just new again? Is it the same? Is it the same that it's always been? Is it exactly the same? Has anything really changed? Has anything changed at all in the last 500 years? Or is it exactly the same? What do you think? Will I be back before Tuesday? That is a reasonable question. I don't know the answer to that question right now. I'm not promising. I'm kind of looking forward to a little bit of a break. If I decide to, strip off all my clothes and run through the streets or something, maybe there will be a news report about that. But otherwise, I don't know if there'll be a lot of uncivil news coverage between now and then. I don't know. So, yeah. Yeah. Ecclesiastes, right? Ecclesiastes chapter 1, verses 1 through 2. Right? Meaningless, meaningless. Everything is meaningless, utterly meaningless, and there's nothing new under the sun. Ecclesiastes knew what it was talking about. It's all been done. It's all been done before. Woo-hoo-hoo. And so forth and so on. Well, in any event, I'm going to take 40 minutes off and, work on my questions. But that's what I want to ask about. There's a big sale on Joma Shop? Okay, maybe I'll check that out too. Maybe there's something on Joma Shop I want to pick up. Maybe I'll check that out. All right, I'll see you guys later. Until later, I've been Uncivil Law. Bye.